Good morning, everyone. This is Andrew Phillips, the business manager over at Phillips Accountancy Corporation. I want to thank all of you for joining us this morning. And I think this is going to be a great informational webinar. Anita's webinars are always so great. We do them every year with her, and every year they get packed like this one. We're expecting about 50 to 60 people here today, but we're going to go ahead and get going. So a couple of housekeeping items before we start. First of all, the link to the handout is in the chat feature. I'll put that in there again for anyone who just joined us. So it's a short, kind of a weird looking link, but that's so you don't have to click on a massive one. So that handout is available online. Keep in mind that the chat feature is reserved for technical or non-Q&A issues. So any questions that you have for Anita, please use the Q&A function for that. Please don't use the chat. She just won't probably see them. We want to make sure that they do get addressed. The second issue is that we are going to be doing, if you're interested in getting the continuing education credits, we are going to be doing 4 continuing education polls. You have to answer 3 out of the 4 polls. They're just easy polls. I'll show you what they look like right now. So I'm putting a poll up. You should all see the poll. If for some reason you don't, please say so in the chat right now. This is just the test one, but I see some of you are answering it, so that's perfect. This is what you will need to answer 3 out of 4 times in order to get the continuing education. So the other thing is, please, if you have a question, please use the Q&A. Please don't do the raise hand feature. When I see a hand raise, I'm honestly just going to lower it, and I'm going to remind you to use the Q&A. So. Perfect. So we will go ahead and get started. Anita York is the speaker today. Many of you know her, but for those of you who don't, she is a partner at the law firm of Scott & Whitehead. Scott & Whitehead is a labor and employment law firm. They do litigation and counseling. And so on behalf of employers, Anita has litigated on a variety of areas, including discrimination, harassment, retaliation, wrongful termination, and wage and hour claims. She also counsels counsels employers on a broad range of employment-related matters. She conducts management training programs and seminars, and she also prepares employee handbooks, policies, and agreements. So, Anita, I'm going to let you take it away right now. And once again, anyone has any questions or technical issues, or rather questions for me or technical issues, please use the chat function. Anita, go ahead. You take it away.
So last month we talked about the employment relationship. We talked about it in the context of pre-hire, looking for the right candidates, interviewing. We went through the management relationship itself, communicating, documenting, all those really fun kinds of things. Got through terminations and a little bit of post-termination stuff. So today's program, Employment Law 102, is really kind of the meat of keeping yourself out of trouble. And when I talk to groups about what kind of programs do I do, and, can I speak to the groups, and what's the one program that is probably the most important, hands down, this is it. Wage and hour is so incredibly important. And I talk to dentists a lot, and oftentimes once they've gotten a claim or a threatening letter from a lawyer, one of the first responses is, look, I treated everybody really well. I paid everybody really well. Like, this is all ridiculous. Here's the problem. If you don't cross the T's and dot the I's, then the better that you paid, the worse off you are. Because penalties are based on how much you paid. So if you pay somebody $50 an hour and the penalty is 1 hour of pay per day for something, another penalty is 30 days of pay, then however much you paid them is actually going to hurt you. Now, that's not to suggest that you shouldn't pay well. It absolutely is to suggest that you shouldn't assume that if you pay well, everything is fine. There are so many T's to be crossed, so many I's to be dotted. When I've been doing this program for many years, and when I used to do it, I used to say there are 7 volumes just of the labor code. Now I have to say there are 8 volumes just of the labor code, which gives us a bunch of this wage and hour law. It also gives us the really great workers' comp stuff. So wage and hour is a very big deal for multiple reasons. First of all, it's the most common mistakes I see dental practices make. When I become involved with a dentist, and whether we're doing the employee handbook or we're looking at an attorney letter or a labor board claim, whatever it is most common for me to find some wage and hour mistakes. It is also the most easily solved. The nice thing about wage and hour is it's sort of black and white, right? It's either right or it's wrong. If it's wrong, you can fix it. If it's right, great. You're not vulnerable. You can't be held liable. There's not a thing. When we're, last month when we're talking about wrongful termination and, is somebody happy or unhappy with getting written up or getting a final warning, that's all a little bit gray, and you got to like really use your head to figure out, how do I communicate best, and how do I say it, and how do I write it, and is the message going to get across, and will the jury understand? Wage and hour is black and white. Either you're paying them right or you're not paying them right. Either they're classified right or they're not classified right. So it's the easiest to fix once you make the decision that you want to fix it. It is the most expensive because exponential penalties just keep adding on and adding on. We're going to go through some of that a little bit later. But I actually enjoy giving this program because I feel like it is the one way in which I can teach you, here's how to do it, and you will keep yourself out of trouble. One of the gifts that the California legislature has given us, and they've given us many gifts, is that they realized that employers were largely, when they got these wage and hour claims, were largely sort of saying, you know what, I'm just going to bankrupt that entity and I'll start over. So they said, well, you know what, that's not really fair to all those folks who you didn't pay wages to properly. So they gave us Labor Code Section 558, which says, among other things, that any person who is making the decisions, making the payroll decisions, making the compensation decisions, setting the policies and procedures for the business, in addition to that individual person being able to be held liable for all the unpaid wages and penalties, in addition, there's this whole other penalty that exists just for that individual, $50 for each underpaid employee for every pay period. For the initial violation, which means the first pay period in which there was an error, $100 per pay period for every employee for every other pay period. So I'm going to talk later on about all these penalties. Keep in mind, this one's on top of all that can be held against you personally, in addition to all the unpaid wages that can be held against you personally. In addition, plaintiffs' lawyers get their attorney's fees. So plaintiff goes in saying, hey, I've got this thing. The lawyer says, no problem, I'll represent you. It won't cost you a dime. You don't have to pay me anything. I'll just split whatever we get at the end with you. So what the employee gets at the end of that is an award of damages, possibly, an award of penalties, an award of interest on all the unpaid wages, and that employee gets his attorney's fees. The employee and the attorney then get to share in that bounty. Now, if you win, do you think you get your attorney's fees? Is it sort of a, well, if you win, you get yours, and if I win, I get mine? No. The employment laws are written for the employees. And as I said many times, the day you became an employer, you became evil. You became a bad person. You are no longer somebody who the law in California wants to help and protect. They want to help and protect employees. So damages, penalties, attorney's fees, interest, all those things get thrown at you if you don't cross your T's and dot your I's on all this fun wage and hour stuff. So hopefully I'm going to help you to do that today, taking you through the following topics. First, we're going to talk about classification in the context of, can somebody be an independent contractor or must they be an employee? Once we narrow down who the employees are, we're going to then talk about, are they exempt or are they non-exempt? Those are the only two classifications that exist in the world for employees. They're one or they're the other. We're going to talk about minimum wage and why it matters. I know that almost none of you, possibly none of you, pay any of your employees minimum wage, but minimum wage actually might still apply to you in the context of salary calculations, and I'll tell you why. The most critical wage and hour rules. So almost all of your employees, if not all of your employees, are going to fall into what we call the non-exempt category. And there's 6 rules that you must apply to all non-exempt employees. So we're going to talk about those because that's where we get where we get the crux of all these penalties that can be applied. We'll talk for a few minutes about alternative work week schedules. Is there an option for you to perhaps decrease your potential overtime liability? We're going to talk about then some other topics. We're going to talk about vacation, PTO, and paid sick leave here in California, how all that works. And then I've got about 8 other kind of hot wage and hour topics that I want to talk about. So here's the way I'm going to kind of set it up. We're going to go through classification, And then I'm going to ask if we have any questions. I'm going to go through the minimum wage, the wage and hour rules, the alternative work week schedules that I'm going to ask for questions. We're going to go through the PTO, sick leave. I'm going to ask if there's any questions. We'll then do the hot topics, and then we'll do a Q&A at the end. So there'll be 4 opportunities for questions. As Andrew said, please put your questions in the Q&A. And then when I get to those break points, well, I'll ask Andrew if we have anything in the Q&A on those topics. Feel free to put questions in the Q&A that are off topic, but I just know I'm not going to answer them at those points. Anything that's off topic or anything else that you want to ask, even if it's like, a topic we covered earlier, we'll take all the rest of the Q&As at the very end of the program. Okay, Andrew's going to do the polls. I am going to try and remember when he brings the polls up to tell you that there's a poll up, so that if you're looking at your handout and you're not looking up, hopefully that will get your attention to tell you that there's a poll question up. If I forget to do that, I've asked Andrew to just jump in and interrupt me and tell us that there's a poll question up there. We will probably add you to our email list for legal updates and for these kind of announcements. If you get an email and you don't want to be on our email list, please just hit reply, take me off, and we are happy to do that. If you have questions, obviously remember this is not a confidential communication. So if you want to email me something in private, please feel free to do so. Andrew will put my email address up into the chat. It is also on the very first page of that handout that you have. And I'll try and remember to say it towards the end, but it's just anita@employerlaw.com. And last but not least, and I almost always say this in these programs, I apologize to you now for talking fast. I talk fast anyways, but we're going to put all this wage and hour stuff into a 2-hour program today, because I truly just don't think that human beings can sit in front of a webinar for more than 2 hours. Although when I have you all in person, this is usually a 3-hour program. So let's see if we can jam it all in. All right, jumping into our first question of classification, which is somebody an independent contractor or are they an employee? This applies primarily if you're hiring an associate dentist. I hope I don't need to say that your hygienist cannot be an independent contractor. Your office manager cannot be an independent contractor. Your chairside assistant cannot be an independent contractor. You may have some other folks that you're kind of thinking about in the context. Can my billing person be an independent contractor? Can my lab tech be an independent contractor? So think about the analysis that I'm going to be talking about in those contexts, but I'm primarily discussing this in the context of an associate dentist, because that's usually where I see it with my dental practice clients. So independent contractor is a legal status. It's a legal relationship. You don't just get to choose whether or not you want that person to be an associate dentist. The law defines who qualifies as independent contractors. And here's kind of the bottom line. An independent contractor is an independent business entity. So independent contractor is someone who's in business for themselves. Associate dentists usually aren't. Let's go through that in a little bit more detail in a few minutes. So let me start out with this kind of by giving you context. First of all, different forums have different rules. Here's what I mean by that. If you are being looked at by the IRS, if you are being looked at by the Federal Labor Board, feds have different rules than states have. In this context, as in many, California's rules are much more strict than federal rules. So if you're being audited by the IRS, or you're being audited or looked at by the Department of Labor, and I've gone through audits for both of those entities, independent contractor status is much easier to prove and to prevail in those federal reviews. Most of the time, it is not going to be a federal review that causes the challenge. Most of the time, it's either going to come from the California Labor Board because somebody has somehow gotten their attention, or it's going to come from the EDD because when they see a lot of 1099s on your filings, your tax filings, the Franchise Tax Board and the EDD get together and they create an audit. Or it may come from a California attorney who's taken on your former associate dentist as a client, and the challenge is coming from that context. So if you have a state context, California state context for the challenge, then let me tell you about the rules. We used to have what we called the Berello economic realities test. So the Berello was a Berello and Sons versus the Labor Board 1989 case in which the California Supreme Court gave us basically what we call the economics realities test. It's 10, 15, 20 factors, depending on how you count them, that you look at to see is somebody an independent contractor. 2018, California Supreme Court said, you know what? In the context of labor board claims, wage and hour claims, not just labor board, but wage and hour claims, it really boils down to just three things. We've all overcomplicated it. Let's simplify it. It's just these three things, the dynamics ABC test, which I'll talk about in a minute. And everybody was up on arms and said, no, you can't, like the judges, the courts can't just change the law and say everything we've been doing since 1989 is out. And now there's these three things. So California legislature got involved. You had half of the California state world employees union saying, yes, ABC test is great. It should be the law of the land for all purposes. You had a bunch of employer groups, including your CDA, saying, no, this is ridiculous. You can't change the law. And even if you do change the law, it certainly shouldn't apply to my group, dentists. So the legislature basically said, we'll split the baby. They passed AB 5, and AB 5 basically says, okay, ABC test is the law of the land, but here's a couple dozen exceptions. Those exceptions include dentists, yay you. The exceptions basically say the ABC test does not apply to you, but the old Berello economics realities test does apply to you. So AB 5 did not say that dentists are exempted from the independent contractor status rules. It just said you don't have to meet the 3 ABC test rules. You have to meet the Berello economic realities test rules. So in your handout, which I hope you have in front of you, if you want to turn to page 4 kind of outlines for you the ABC test and the dynamics, kind of what we got from the dynamics case. It then goes on to talk about AB 5, which said, okay, ABC test applies to some folks, but not to other folks. So on page 4, I've given you the exemption for dentists, and I've done this because I want you to see that it says, instead, the determination of employee or independent contractor status for individuals in those occupations shall be governed by Berello. It does not take away the test. It just says you go back to the test. So the old test becomes the new old test for dentists and many other kinds of individuals. So the bottom line is this: the tests are actually kind of the same. The concepts are the same. So if you look at the ABC test, you can see those three things. It's really easy to just see what those are and use that analysis to inform you as to whether your associate dentist is or is not a bona fide independent contractor. Alternatively, go to page 5, the Berello factors. On page 5, I've taken you through a list of about a dozen factors and answer those questions. And when you're looking at that, you don't answer them in the way that you think you would want to see the answers. You need to step outside of yourself, be a judge, be a labor board commissioner, look at the facts of your situation and evaluate objectively. Chances are, for an associate dentist, you are not going to pass that test. So let's talk about what the test is in basic terms. First of all, it means that the practice has no right to control the contractor. It's not just a question of do you control the contractor. It's do you have the right to control the contractor. So when you hire an associate dentist, what I hear from my clients all the time is, I don't control her. She does what she wants. She practices dentistry however she wants. If she wants certain supplies, we order them for her. If she wants equipment, we order it for her. I don't babysit her. I don't train her. I don't evaluate her. She does her thing. That doesn't mean that you don't have the right to do all of those things. If you start getting patient complaints, are you just going to sit back and let it happen? Or are you going to call in that associate dentist and say, this is not acceptable. You are too heavy-handed. You are too harsh. I've had 5 patient complaints. We've got 4 bad Yelp reviews now. You cannot continue to operate this way. You must change, right? Because you have the right to control that person, even though they're certainly practicing dentistry using their own skills and experience. The contractor doesn't provide or perform the same tasks. Very important. When you hire an associate dentist to come into your general dentistry practice, chances are that associate is coming in to perform general dentistry. Different situation if it's someone who's coming in to do something different. So one of my partners is working with a dentist right now who's a general dentistry practice, and they brought in an endo. And there's now a dispute between the dental practice and the endo's asking for tens of thousands of dollars because things weren't done right. One of the arguments was that person an independent contractor or not? Well, in the column that's on our side, the endo is doing root canals and endo things that the general dentist does not do. That was a great thing on our side of the column. Not so great is the reality that that endo is going to come in every day. And even though that endo is bringing their own supplies, bringing their own equipment, doing their own thing, the general dentist doesn't do root canals. The general dentist practice still had the right to manage, control, direct that endo. The third factor is the contractor is recognized as a separate business. So in our case right now with the endo unfortunately was just doing work for that one dentist. If that endo, on the other hand, had been doing work for 5, 6, 7, 8 dental practices, that would have certainly been evidence that that endo is recognized as a separate business. Excuse me, frog in my throat. And we'll talk about that a little bit more in a few minutes. But pages 4 and 5 will kind of take you through the test, take you through the factors, hopefully help you to see, objectively speaking, whether or not an associate dentist who works for you may or may not be properly classified. Here's what we hear oftentimes, because historically, associate dentists were always classified as independent contractors. And historically, nobody cared, nobody looked at it. Even when there were audits that were happening through with these, whether it was the IRS or the EDD, if there was a contract and there was, the entity was incorporated, so it was your corporation paying money to that corporation, the agencies even would just sort of ignore it. They'd say in the audit, and I've seen the audit reports, they would say independent contractor between corporation and corporation, not analyzed, not reviewed. They would just ignore it. It was sort of a safe harbor, unwritten rule that if you got those things in place, we'll leave it alone. That's not the case anymore. And I will tell you my very jaded lawyer opinion, they're all looking for sources of revenues. The IRS, the EDD, the labor boards, whatever, they're all looking for sources of revenue. And misclassification as an independent contractor is a source of revenue. They get to charge you penalties and fines and late fees and interest and all those fun things. In fact, one of the big cases I've had was one of a client that came to me from Phillips Accountancy many years ago. And thank goodness she had Bob for her accountant, because when they came in and said you have 2 associate dentists who are misclassified, they initially wanted $125,000 in back taxes that were not paid, supposedly employer taxes not paid, interest, penalties, blah, blah, blah. And Bob got that down to, I don't remember, something like $5,000 or $10,000 after months of representing her. And I was working with her and we were coming up with all the arguments. But still, she paid him money, she paid me money, she reclassified everybody. It's a big deal. They're looking for money. So yes, if you're going to classify somebody as an associate, as an independent contractor, I hope they're an entity. I hope there's a good written contract. If you decide, you know what, I get that this is a risk and I'm just going to do it anyways, let's at least get those pieces in place. It's not going to be a slam dunk, but hopefully it will be helpful. All right. So what they're looking at is the person really independent? Do they own their own business? Do they run their own business? Do they operate their own business? Do they have their own business expenses, profits and losses, those sorts of things? But at the end of the day, it's up to you to decide whether you're willing to take the risk. Then let's cross as many T's and dot as many I's as we can. And if you're not, let's get them converted to employee status. All right. What about a seller dentist? When you're buying a practice, I would say 99.9% of the time, the seller stays on for some period of time and stays on as an independent contractor, right? That seller dentist already had their corporation. That corporation's been in business for all these years. When you buy a practice, you basically buy the assets of the practice. You don't buy the corporation. You don't buy the shares of the corporation. So you bought the assets. All the employees are terminated on the day that the deal closes. They're rehired by you the following day. And the seller dentist oftentimes stays on for some period of time. As an independent contractor, your corporation pays that corporation. In reality, legally speaking, there's no exception for that context. But in reality, I will say, if there's an exception that you're going to make or a risk that you're going to take, that's where I would take it, because at least that seller's corporation has already existed and had income coming in for many, many years. Hopefully that's not going to be as much of a red flag. But here's what I want you to consider doing. Rather than keeping that seller dentist on as a treating dentist, right, to just keep treating patients for a year or 2 or 3 or 4 or 5, I want you to strongly consider keeping that dentist, that seller on as a transition consultant, right? The idea should be that you've bought the practice and the seller is going to stay on to help transition. They may still treat some patients, but the goal is to transition them to you. The goal is to introduce them to you. The goal is to convince them that the seller thinks you're great. They're going to be so happy staying on with you. Seller's here transitioning because they want to make sure there's a smooth process. Seller's going to help you sort of figure out like who's who and what's what and how do the systems work and what software do we use. How do we context? I think you are all day long to classify that person as an independent contractor. In addition, I want you to really consider the reality. Oh, shoot, my internet connection is unstable. I don't know why I'm having problems today. I'm so sorry. In addition, I want you to consider that in reality, if you keep a seller on for too long, that can actually cause some problems. Patients don't transition. Staff doesn't necessarily transition. They keep going back to the seller when they're unhappy with you and they've got, sort of mom versus dad kind of thing. So I really want you to think about the health of the future of your practice is best served by having that seller transition to you the entire business, patients, employees, assets, everything, and transition out of the business, hopefully in 6 months or a year. Lee Maddox and I have talked about this for many years. He agrees with me. I've talked to other consultants. They agree. It is not healthy to keep a seller on for a long time. Oftentimes, it's not always the case, but oftentimes. All right, so examples of who can be an independent contractor. I've already talked about that endo situation. So we do have absolutely mobile dentists. Some of them are my clients who basically set up their business as a mobile business. And they go from practice to practice saying, I'll do a day for you here, I'll do a day for you there. They come to you once a month, they come to you twice a month, they come to you once every other month. They have 5, 10 other dental practices that they go to, and they truly are an independent business. That's an independent contractor all day long. Your IT professional, your marketing consultant, maybe an outside billing service. If you look at all those Berello factors, those are mostly going to meet those factors. It's an independent business. They're not doing the same thing that you exist to do. You certainly don't control them. They tell you when they're going to do their work. Those are all examples of independent contractors. So if your associate dentist doesn't kind of look like that, not properly classified as an independent contractor. All right, why does it matter? Government agencies are auditing. Plaintiffs' attorneys are getting all excited about misclassification. As soon as somebody walks in the door and says, I was an independent contractor, plaintiffs' attorneys, like, fireworks start going off in their head, with all the dollar signs. Many, many monetary consequences to misclassification, including potential for $5,000 to $10,000 if you've got one, $15,000 to $25,000 if you've got multiple. Those are just one area of penalties. All right, Andrew, do we have any questions on independent contractor status?
I'm not sure. There's one that says, is it okay to pay a staff member, specifically a hygienist, on a per diem basis?
We are going to talk about that in about 15 minutes.
Okay, perfect.
Okay, good. I will continue on. All right, so once we've decided who our employees are, we then have 2 classifications for employees, and there are only 2. There's no exceptions. There's nothing else. Every single employee falls into one of these 2 classifications. One is exempt. One is non-exempt. We get this law from what we call our wage orders. Wage order number 4 applies to dentists. If you're not familiar with your wage order, you should be. We get these instructions from the labor code. Remember our 8 volumes of labor code? A bunch of it talks about classification of staff as exempt or non-exempt and what rules apply to each. In addition to that, we have our code of regulations. We have case law, like the Dynamics case and the Berello case. We have other statutes that come into play here, Equal Pay Act, Fair Pay Act, and we even have federal law that comes into play sometimes, not usually, because of course, California law is so much stricter that it's usually the California law under our wage orders and our labor code that if there's going to be claims or violations, it's usually as to those. Okay, so what does exempt or non-exempt mean? Exempt means that you are exempt from wage and hour rules. Non-exempt means you are not exempt from wage and hour rules. As a young lawyer, it took me a little while to realize it's like a double negative, right? Exempt means you're exempt, but non-exempt means you're not exempt, which it kind of threw me for a while. Okay, so let's talk first about exempt, because of course that's our preferred classification. You're exempt from the wage and hour rules. Who can be exempt? There are 2 tests that must be met for somebody to be exempt. Both tests must be met. The first one is what we call the duties test, meaning what is their job. Second one is the salary basis test. So the duties test basically says, if you are a higher level kind of employee, and I hate to say that because it sounds so judgmental, but that's kind of the concept. If you're a higher level kind of employee, then you may be able to be exempt. The idea being, I think, that you are high level enough that you can negotiate your own deal. You're doing higher level things that may not fit into the box of the wage and hour stuff. And since you're going to be more highly paid usually than our non-exempt employees, we can take away some of those wage and hour rules. So what jobs qualify in a dental practice? There are many other jobs that qualify in other businesses, but for dental practices, here's the jobs that qualify. An associate dentist automatically meets the duties test as long as they're California licensed and they're actually practicing dentistry. So I've had dentists say to me, I have a dentist who's licensed in another country. She hasn't taken her boards yet here, so she's working as a hygienist. Can she be exempt? No. Has to be a dentist who's actually practicing, a practicing dentist licensed to do so. So that's one category. Another category is a business administrator type. And you'll notice I didn't say office manager, because in dental practices, office managers is usually the front desk person who happens to be sort of in charge. So if you want time off, you give her the request form. If you have a question on your paycheck, you tell her you have a question on your paycheck. But usually that front desk office manager person doesn't really do enough to qualify as exempt. And here's what I mean by that. Business administrator who spends more than half of their work time actually managing the business. So if you've got a front desk office manager, that person at the front desk is scheduling patients, answering phones, maybe doing some billing, maybe doing treatment coordinator stuff, financial coordinator stuff. That's all non-exempt work. That's not managing the business. So an exempt business manager, based on the duties test, who spends more than half the time managing, even at the front desk. They have a desk in an office somewhere back there because they don't have time to be taking care of all the patients. They're busy managing. That's probably the case if you have 4, 5, 6 dentists. You have 4, 5, 6 hygienists. You have 10 chairside assistants. You have 5, 6 front office people. So basically you have an office with 20, 25 folks. Now you probably can justify having a business administrator whose sole job it is to keep that business running. Make sure that you're hiring, make sure that you're firing, make sure you're evaluating, make sure you're training, negotiate your contracts, do the big ticket stuff that a business administrator does. Other categories, certain relatives, your spouse. Doesn't say registered domestic partner, but I would argue that a registered domestic partner also qualifies because California law says that a registered domestic partner is to be treated the same as a spouse. So your spouse, your parent, so one level up, your child, one level down. No other relatives apply. I actually have a friend who had a case where the labor board came in, and this was a business that had a bunch of family members working. And they said, okay, so your spouse, parent and child are out, but your sibling, no, they are misclassified. Your niece, misclassified. And so we had to argue that argument whether they really qualified as exempt or not exempt under the classifications. All right, again, there's other categories, they don't apply. So hygienists are not exempt. Most office managers are not exempt. Your chairside assistant is never exempt. Your other front desk person is never exempt. Your lab technician is never exempt. These are the folks who will meet the duties test. So the first of our 2 tests, associate dentists, business administrators. So if you have those 2 folks, then the second part of our test is what they call the salary basis test. And the salary basis test basically says that your exempt employee must earn a base salary, fixed base salary, not just compensation, fixed base salary that is no less than minimum wage times 2 times 40 hours, no matter how many hours they work. So if you have an associate dentist who's working 1 day a week, exact same test, minimum wage times 2 times 40. So minimum wage, I'm sure you know, is going up every single year through 2023. We'll see what happens beyond that. For now, as of January 1 this year, minimum wage is $13 an hour. If you have 25 or fewer employees, it is $14 an hour. Did I say 13? It's $14 an hour if you have 26 or more employees. So to do that calculation, $10.40 per week for an individual to be exempt, $11.20 per week if you have 26 or more employees. The minimum is weekly. The minimum is 40 hours. So it doesn't matter if you're paying somebody who's only working there 1 day a week. The minimum for a week of pay salary for exempt status is $10.40 or $11.20. Some of you will live in cities or counties that have a higher minimum wage. That does not apply to this analysis because this analysis is under state law. So even though your city or county minimum wages apply to minimum wage, does not apply to this calculation. So monthly minimum salary, if you're going to figure it that way, is $45.07 or $48.54. If you pay on a semi-monthly basis, you just cut this in half. That gives you your semi-monthly minimum required salary. And I put in the annual just because to demonstrate it's a lot of money. For someone to be exempt, they're earning quite a bit of money in base salary. So base salary means it is a fixed amount that that person gets every week that they work at all, no matter what. It's not that they earn that much in production or collections. They must earn that much in a fixed, guaranteed base salary. All right, so what does this mean? It means that daily rate fails. So your question, can hygienists be paid on a daily per diem? They're not exempt under the duties test. They're not exempt under the salary test. They're going to be non-exempt. So we're going to talk about what that means in the non-exempt discussion. So daily rate fails for associate dentists. If you're paying your associate dentist $600 a day, $800 a day, you have just made them a non-exempt employee, which means every rule that applies to your chairside assistant applies to your associate dentist. Production or collection fails. You have to have a base salary. So the way we do this is we write the base salary, and then the collection or production payment is above and beyond whatever the base salary is. So for example, if the base salary is $45.07 per month, then we say, and then you'll get 25% or 35% of collections that are above and beyond that base salary amount, right? So we write it so that there's the base salary plus, so that we meet the exemption test. So every January 1st, that minimum base goes up. So make sure that when we're doing that contract or reaching that agreement, that weekly or monthly amount is set to increase every January 1st. So if you set it up now, you aren't then in violation in 2022. All right, so exempt employees must meet both of those tests. If they don't, then they are automatically non-exempt employees. There's only two categories. They either meet the exemption test or they are automatically non-exempt. Why does that matter? Here are the 6 requirements that apply to all non-exempt employees. First of all, they must be paid overtime. California, that means over 8 hours a day, 40 hours a week, must be paid overtime at time and a half. We have just put up the first polling question, so please do go ahead and answer that polling question. Let's see, but I need to move it out of my way. All right, they must be provided non-working meal periods. So at least 30 minutes, non-interrupted. They're not answering your questions. They're not answering the phones. Meal periods. By the way, we're going to go through all these in detail in a minute. Third requirement for all non-exempt employees, they must be provided non-working rest breaks, 10 minutes mid-morning, 10 minutes mid-afternoon. They have to keep accurate time records. They have to clock in and out. They must get their pay stubs that have certain information on that, what we talk about, and they must be paid for all time worked, which we'll talk about. All right, let me start with overtime in detail. Again, that poll question is up, so if you're looking at your handouts, please pop your head up and answer the first attendance poll question. All right, let's talk about overtime. What does that mean? If you pay somebody on a salary basis, but they are a non-exempt employee, that's perfectly fine. But all the rules still apply. They still clock in and out. They still get paid overtime. So if you want to guarantee somebody $1,000 a week in base salary, that's perfectly fine. But if they're non-exempt, then they get that plus they get overtime. So let's say they work 40 hours a week. Let's say you pay them $1,000 a week. That's $25 an hour. If they work overtime, they get overtime at $37.50 per hour of overtime, even though they're salaried. Therefore, I don't usually recommend that you pay somebody salaried if they are not exempt. Over 8 hours a day or 40 hours per week. Potential exemption under the alternative work schedule, which we'll talk about probably in about 15 minutes. Important for you to understand that wages are due for all time worked. I'm going to talk about that in a few minutes, but in the context of overtime, if you're paying a daily per diem to a hygienist, not only you're not paying overtime, you're not paying for all time work. Let's say you pay that hygienist $400 a day. Let's say she works 8 hours a day generally, right? She works 9 to 5 with 8 to 5 with a 1 hour break for lunch. That's 8 hours for the day. But let's say she works 15 minutes in the morning because she comes in, she gets her operatory set up, she reviews the charts for the day and gets ready. Let's say she works 15 minutes after 5. Patients ran a little late, she's cleaning up, she's finishing up, she's restocking her supplies for the next day. So she's actually worked 8.5 hours for that day. If you paid her daily per diem of $400 per day, not only did you not pay her overtime, you didn't even pay her for all of the time that she worked. That means 2 different ways that she's going to get penalties against you, 2 different ways that she's going to come at you for unpaid wages and unpaid overtime, different statutes, going to throw the book at you. So can you pay a daily per diem? If you want to, just like I said with the salary above, you can, but that does not change the fact that all 6 rules apply to that hygienist. Must clock in and out, must be paid for all time work, must be paid overtime. So if you want to guarantee that hygienist $400 a day, that's fine, you can do that. But understand that the law says that calculates out as $50 per hour. You still owe any time that that person works in excess of that 8 hours per day. And you owe it at the overtime rate if overtime applies. All right. Second requirement for all non-exempt employees must be provided non-working meal periods. So if the person is going to work more than 5 hours, they must be provided a non-working meal period. So we have dentists who are open, for example, every other Saturday, and they're open from 8 to 2. That is 6 hours. That's more than the 5 hours. So skipping that lunch may be a problem. If they're open from 8 to 1, that's fine. You don't have to provide a lunch, but the employee should not start work before 8, should not end work after 1 o'clock, because if they work 5 hours and 5 minutes, 5 hours and 1 minute, they were entitled to that meal period. So make sure that you're bookending your times properly if you're going to have a day that someone's working less than 5 hours. Now, if they're not going to work more than 6 hours, then you can have a written agreement that says, I agree that if I don't work more than 6 hours, I want to skip my lunch. The agreement has to say certain things. It also must say the employee can revoke the agreement anytime. So don't just think that they can just write out a sentence that says that. That's not enough. Ask me for my meal period waiver. I'll send it to you. So if they're going to work more than 5 hours, they're entitled to a lunch. If they're not going to work more than 6 hours and they've signed a meal period waiver, they can choose to skip their lunch. But here's the confusing part. If they're going to work more than 6 hours and they're going to get their lunch, that lunch has to begin before the end of 5 hours. So the 5-6 hour rule is very confusing. A lot of people get it wrong. It's 2 different rules, 2 different things. If an employee is going to be working such that they're going to get a lunch break, that lunch break must begin before the end of 5 hours of work. So if an employee begins work for you at 8 a.m., his lunch must begin by 1 p.m. If that employee comes in at 10 minutes to 8, then that 1 p.m. lunch is a late lunch, and there's a penalty violation for that. There's a violation penalty for that. So if they're going to start work a little bit before 8, do not schedule them for lunch at 1. Schedule it at 12, schedule it at 12:30. Give yourself a little bit of buffer. Do not schedule it at 1. Must be at least 30 consecutive minutes. That means they cannot be answering phones. They cannot be answering your questions. They cannot be running in to check out that patient who's running late with the hygienist. 30 consecutive minutes, uninterrupted, leave them alone. They're not working, must be allowed to leave the premises. I want you to instruct your employees that when they go to lunch, if they stay on the premises and that you or anybody asks them to do something, I want you to instruct your employee to tell that person, I'm on my lunch. I know it sounds rude. I know it sounds like that employee is like not going to be remotely comfortable saying that, but it will be very helpful to you if that employee is not interrupted during their lunchtime. Otherwise, their lunch is supposed to start over because all that is now considered time worked. All right, they must clock in and out. It must be accurate. So it can't just be that you automatically deduct 30 minutes for lunch or an hour for lunch. They must clock in and out. It must be accurate. You cannot automatically deduct for the meal period. So if they didn't clock out, you can't just say, oh, I know she took a lunch. I'll clock it in and I'll clock it out for her. You need to go back to that employee and say, hey, on Monday, you didn't clock out for lunch. You know, do you want me to adjust the time record? And if she says, no, I didn't take a lunch that day, then you need to deal with that reality. Lunch meetings and trainings are time worked. That employee is working. So even though you're feeding that employee, that is time worked. So for example, in our office, every Tuesday at 12 noon, we have a staff meeting. We bring lunch in. By the way, we're all doing it by video conference now, but we do that. When that lunch meeting is over, our staff begins work at 9. So when that meeting is over, which is usually about 1 o'clock, they rotate through their half-hour lunches, even though they've already eaten. So their half-hour break, they can go take a walk, they can read a book, they can listen to their iPod, whatever they want to do, but they have a half-hour off because that staff meeting, even though we fed them, is not a lunch break. So lunch and learns. The way I suggest you do them is if a vendor wants to come in when we're all done with COVID shutdowns or COVID restrictions, vendor wants to come in, bring lunch and show you the new latest, greatest software or equipment, that's fine. You instruct that vendor. If you want to arrive at 12, bring lunch, that's fine. For the first 30 minutes, you may not discuss business whatsoever. You may not introduce the software. You may not do anything. You can chit chat, visit, how was your weekend, whatever, that's fine. But that is the employee's time to go off, do what they want to do, eat their lunches, be on their phones, no business. At 12:30, you may begin your discussion of whatever the product is. That's how you make sure that they've gotten their half-hour lunch break during a lunch and learn, because they didn't have to be there. There was no work being conducted. They were not under your control. They did not need to be listening to anybody talk about business. They're back at 12:30. Now they're back on the clock because they're now hearing about the new software. Other potential waivers. If you have a business, for example, that does oral surgery and it's going to be putting somebody's health at risk, if your assistant says, I'm going to lunch now in the middle of a procedure, there's a special on-duty meal period waiver that can be signed that basically says that person's taking an on-duty meal period, which is a misnomer, but that's just what they call it. That basically says, I understand that there's health and safety risks if we're in the middle of a procedure and I cannot take my break. So I agree to an on-duty meal period, which in reality just means they're going to take a later lunch. So that is really the only context in a dental practice in which that on-duty meal period waiver would apply. It does not apply just because they're the only front office person. It doesn't apply just because they're only the only chairside assistant. It doesn't apply because you work through lunch because some people need to come in through lunch. It only applies if there's a health and safety risk that you cannot schedule around. You can't schedule that patient earlier or later, and they cannot leave you because it would create a risk. So have a good written policy about meal periods. Follow that policy. I hate to say it, but it is far too common that I have claims. I've got one right now for tens of thousands of dollars. And the claim is basically, yeah, we all took lunch breaks, but during our lunch breaks, doctor would ask us questions. We'd answer the phones when they rang. And it's not a matter of he required them to do it. It's a matter of they did it. He knew they were doing it, which means he was permitting them to work through their lunch breaks. That's a problem. You cannot permit, you cannot require, tell people half hour, you may not work. All right, third requirement, 10-minute rest breaks. This is the one that we see with almost every claim in a dental practice, no matter what the claim is, people throw in the rest break claim. I didn't have time to take a 10-minute break in the morning. I didn't have time to take a 10-minute break in the afternoon. We especially see this with hygienists who are scheduled back-to-back. 10-minute rest breaks are required for all non-exempt employees. No, you don't have to schedule them. No, you don't have to police them. No, they don't clock in and out for them. It's a paid rest break, so they don't clock in and out for them. But you need to have a good written policy that tells everybody they can take their 10-minute breaks. You need to have a realistic procedure for them to do that. Cross-train your front office and your back office so they can cover each other. Cross-train back office and hygienist so that back office, when that hygienist has finished a patient, your chairside assistant can step out of your room, go over, turn the room, do all the cleaning, do all the sanitizing, get the new instruments out, pull up the patient chart, go get that patient, bring the patient in, put the bib on, get the chart up on the screen, get that hygienist ready to go. Hopefully that will buy that hygienist that 10 minutes to take that break. That's the easiest way that I've found to do it. I know it's not easy, but it's the easiest way that I've found with my clients for them to be able to provide rest breaks to their hygienist. I want that to be built into your written policy. I want you to train on it in your meetings. I want there to be no question, but that you make it realistically possible for your folks to take a 10-minute uninterrupted, you're not on call, you're not answering phones, you're not answering questions, paid rest break, mid-morning, mid-afternoon. Doesn't have to be exactly mid, you don't have to count to the minutes, but approximately mid-morning, approximately mid-afternoon. You cannot tack it on to the end of their lunch period. A lot of employers, not so much now, but before all this was as visible as it is now, would just say, look, they're gone for an hour lunch, but they only clock out for a half hour. I pay them for the half hour. That's their morning and afternoon breaks. Nope, does not cut it. The law actually says must be separate, mid-morning, mid-afternoon, cannot be tacked onto the lunch. So they cannot remain available to answer phones, cannot remain available to answer your questions. Don't text message questions to them while they're on their breaks. Must be realistic for them to be able to do that. Must maintain accurate time records is our fourth requirement for all non-exempt employees. So all non-exempt employees, everyone who does not meet the duties test and the salary test, must clock in and out accurately. Clock in when work begins, clock out when lunch begins, clock back in when lunch ends and they resume work, clock out at the end of the work day. That includes all of their time worked, whether it's a morning huddle, getting my operatory ready, whether it's end of the day, finishing cleaning up, restocking my supplies, checking my chart notes, that's all time worked, must be clocked in. If they do on-calls for you, some dental practices have their front office person or their chairside assistant do on-call emergencies. If somebody else who's non-exempt is doing an on-call for you, they clock in for all the time they spend on the phone. If they have to come back to the office for some reason, that is the one time, there's actually 2 times, but that's one of the 2 times that they get paid for their commute time. They get paid to drive back to the office, paid for the phone call, paid for the time working, paid for their drive home. That's just special rules about on-calls. So I encourage you to not have your non-exempt employees handling your on-calls. Do it yourself, have another service do it, rotate it with your associate dentist who's exempt because that associate dentist is paid properly. I would not have your non-exempts doing it. All right, so all time worked must be counted, and it doesn't matter whether you require them to work, they must be clocked in for all time they're working, even if you're not requiring them to work. I also have employers oftentimes say, well, she never clocked in and out right. I couldn't get her to clock in and out right. That's not an excuse. The law says it is the employer's responsibility to maintain accurate time records. So even though you are designating the responsibility to the employee to properly clock in and out, ultimately the law holds you responsible. So if that employee is not clocking in and out, or they're not clocking in and out properly, that is your responsibility. And there's a very heavy penalty to be paid for that I'll tell you in just a minute. All right, I strongly say most dental practices now are all computerized, right? Your patient charts are computerized, staff clocks in and out on computers, and I want you to think about making sure that when there are any changes to those computerized records, that those changes or corrections are signed by the employee. So what happens in these labor board claims or these legal claims is that we have employees who say, I didn't clock in and out that time. My employer changed my time all the time. I didn't clock in and out for lunch. My employer changed my time all the time. That doesn't work. So I want you to have something signed, preferably signed off by the employee saying, please change my time. I forgot to clock out. I forgot to clock in. I clocked out and then I answered a few phone calls. I have a little form that we use. I don't care what you use, but have them do something in writing. It can be email, something in writing that tells you to change the time records. I also really like having some attestation at the end of the pay period or the end of the week that basically says, I reviewed my time records. They're all correct times. Again, it just really helps later if there's a challenge by that employee who tries to say that the employer changed the time records. All right, two other case notes I want to bring up. We used to have employers doing a lot of what we call rounding. If the time that was on the time record was a strange, 11:02, 11:03, 12:07, we would round. We would round to the nearest 5 minutes. We would round to the nearest 15 minutes because we're doing a lot of manual calculations, and manually calculating minutes is a pain. Neutral rounding is okay as long as it's neutral, which means at the end of the day, sorry, I don't mean that literally. If we were to take a look at 6 months or a year of time records and average out the rounding, as long as the employee is not losing wages, it comes out neutral, then it's fine. Too often what happens with rounding, though, is that the employer says, you cannot arrive late. You must be on time and your start time is 8 a.m. So the employee arrives at 5 minutes to 8, clocks in. Our neutral rounding rounds that time to 8, right? Now, if you were to do that calculation at the end of the year, was it a neutral payoff so that the employee didn't lose wages? No, because they usually clocked in between 7:55 and 8 and basically didn't get paid for that 5 minutes all year long. On the other hand, if the employee is allowed to arrive 5 minutes early, allowed to arrive 5 minutes late so that it's neutral and it's a wash, then you're fine. That's not usually the case. So I want you to really consider rounding practices. If you're using computerized clocking in and out, I want you to get rid of rounding practices entirely. You don't have to do the math. The computer does the math. The computer doesn't care if it's to the minutes. It's all programmed. So I encourage you to get rid of rounding policies. But if you're still doing manual and you want to keep rounding policies, that's fine as long as it works out to be neutral at the end of whatever period is being looked at. Second thing, this has become a big thing in case law in last couple of years. There's no such thing as de minimis. So this case came to us from Starbucks, as many cases do. And Starbucks basically said, had managers who are non-exempt because they spend most of their time doing non-exempt things, who said basically, we're required to clock out. Then after we clock out, then we have to shut down the computer system. Then we have to lock the safe. Then we have to take out the trashes. Then we have to shut off all the lights and all that. And then for those of us who work in shopping centers, we are required to escort employees to their vehicles so that there's not one person walking by themselves to their vehicles, and then the last employee drives us back to our vehicle. That's all de minimis. It only takes 5 minutes, but that's time that we're spending working and we're not being paid. The California Supreme Court said, you're right. That is off the clock work, that is unpaid time, and you get not only all those back wages, but a whole bunch of penalties. So no such thing as de minimis work. If somebody's working, they get paid for it. If that means we need to do a time clock adjustment, we do the time clock adjustment. I have a client who is it's not a dental office, but it's a it's a service retail organization. And what he's done is basically set up the time keeping system. So the timekeeping system automatically adds 5 minutes to every employee's clock out time at the end of the day, because he just doesn't want to deal with it. He doesn't want to think about it. He just wants to know that everybody's getting 5 more minutes every single day. If you showed up in the morning and turned on the lights, and you left at night and you turned off the lights, and that took you up to 5 minutes, you're already being paid an extra 5 minutes for every single day. I'm not saying you should do that. I'm just saying be aware that everybody needs to be paid for all their time worked, and accurate time records are required. Fifth requirement for all non-exempt employees, wage statements not only must be accurate, but they must include certain information, including all hours worked. So for example, if you're paying a hygienist a daily per diem, and the daily per diem is $375 a day, the time record, the pay stub is not going to show her hours worked. It's just going to show the daily per diem. That is a pay stub violation, which carries its own penalty. It must show the hourly rate per category. So if that person just worked regular, no overtime, then it may just be the regular $20 an hour that shows up. If they worked overtime, it'll show, 40 hours at $20 per hour and 3 hours at $30 per hour. It must show the hours worked, must show the applicable hourly rate. If you pay different rates for different things. So for example, sometimes we have a situation where you pay hygienists, they're $50 an hour while they're, treating, but during staff meetings or you're going to bring somebody in to do CPR training, you pay them half their rate. You pay them $25 an hour for that work. Paycheck stub must show the number of hours worked at 50 hours, the number of hours worked at 25 hours. If you don't have all those things, that's a violation, separate penalties, and that's probably going to be a problem if you're paying a daily per diem. You may all know that with the paid sick leave benefits requirements, among those requirements is that every payday, the employee must receive a written document that shows what their available paid sick leave benefits are. Most of us are meeting that requirement by putting that on the paycheck stub. So it's not that it's required to be on the paycheck stub, but you're required to give the employee something in writing every payday. Obviously, it's just easiest to put it on the paycheck stub. I strongly encourage you to do that. If you're going to do that, you might as well put the vacation and the PTO on there also. In a little while, we're going to talk about using vacation and PTO as the sick leave to fulfill a sick leave requirement, which is perfectly lawful. But if you're doing that, then again, you're required to give them a record of what's available every payday. Last but not least, all non-exempt employees must be paid for all time worked. If you have somebody who's properly classified as exempt and you're paying that base salary of at least $10.40, then they're automatically being paid for all time work, right? That salary covers all the time that they work, whether they work 10 hours, 40 hours, 60 hours, that pays for all time work. For non-exempt employees, that's not the case. They must be paid for all time work, which means clocking in and out accurately, paid for all the time that they are on the clock, performing any duties whatsoever, whether or not you require them to work. So if you allow an employee to arrive early and you allow that employee to look at the charts, get the operatory set up, and I understand that a lot of particularly hygienists do this because it's just their preference. Like, you don't need to pay me. It's just what I want to do. It makes my day easier, makes my day better. I'm more relaxed if I come in, I see what my day looks like, I review the charts quickly, I make sure I'm all set up, then I go have my cup of coffee. That's fine, but the hygienist must be clocked in while she's doing the work part of that, even though you didn't require it. So So think about how you're going to set that up, no matter what the duties or tasks they are that they're performing. So for example, during rest breaks and while waiting for patients. So here's why I bring this up. If you are paying somebody on a collections basis, let's say a production basis, let's say you have an associate dentist who works 1 day per week. You're paying him on a production basis, paying you 35% of everything that you produce. A, they're not exempt, right? They're not getting that fixed base salary. They're non-exempt. The fact that they're non-exempt means they have to be paid for all time worked, and they have to be paid for rest breaks. If they're being paid on a production basis and during a rest break they're not producing, then the law says you are not paying for their rest break. So you must calculate out how much their pay was, add on 10 minutes every morning, 10 minutes every afternoon, and give them additional pay for their rest breaks. If there's a break in the schedule and they're being paid on a production, and there's a break between 10 a.m. and 11 a.m. and they're not doing anything, that means they are on the clock working for you and they're not being paid. So you have to, again, figure out their hourly rate based on the production divided by the number of hours they worked and pay them for that waiting time. There's a very big case that came down a few years ago on this very topic, and very clear: when you pay on production, you have to pay for waiting time, rest breaks, anytime they're not producing, but they're still supposed to be paid. While attending any business meetings, if you're text messaging with your staff after hours, that's time worked. If you're sending the text message and they have to respond, that's time worked. Do not text message with your staff. Wait until they're at work unless it's absolutely positively necessary. And if you had to text message them, tell them, hey, I'm going to do a 5-minute adjustment on your time record because we were text messaging this morning about Susie not showing up and me asking you to come in early. If they come in early and get started, if they stay late to finish, that's all time work. They must be paid for all time work. So all of which is to say, I strongly encourage you to pay your non-exempt employees on an hourly basis. If you pay them on an hourly basis, most of those problems are solved. They clock in and out, they get paid their overtime, they get paid for their rest breaks, they get paid when they're waiting for a patient, they get paid for all time worked. You solve it by paying them hourly. Make sure they're taking their lunch breaks before the end of 5 hours of work, at least 30 minutes uninterrupted. Make sure you have a realistic way for them to take their rest breaks. You do all of those things, you have just solved almost all of your wage and hour problems. If you don't, what are the penalties? If you don't pay overtime, it's all the unpaid overtime. And if you were doing it as a daily per diem, so they weren't even getting paid straight time for the overtime, then it's exponentially more. Penalties on penalties on penalties, interest, attorney's fees, it adds up. Non-working meal periods, if they don't get that non-working meal period uninterrupted, at least 30 minutes, starts before the end of 5 hours of work, it's 1 hour of pay for that day, every day that happens. They don't get their rest breaks. They're able to take their rest breaks. I'm often asked, do they have to take the rest breaks? No, but you have to make it realistically possible. You must have policies. You must do training. You must do everything you can to make sure they know that they can take their rest breaks. If you fail and they can't take rest breaks, don't take rest breaks, another hour of pay for every day that they say they can't take rest breaks. Accurate time records. Remember I said it's the employer's responsibility to maintain the accurate time records. If you as the employer fail to do that, the employee gets to estimate their time worked. And trust me, they came in way earlier than you thought, and they stayed way later than you thought, and they skipped those lunches and they skipped those rest breaks. That's how those claims go. So not only do I want you to make sure that all your non-exempts are clocking in and out, I want you to take a look at those time records. When you do payroll, spend 5 minutes. Take a look at the time records, see what it looks like, see if that makes sense to you. You might also figure out you're paying a bunch of overtime that they didn't need to be working, but they're milking it because they want the money. Look at your time records, look at your payroll records. If you don't have more than 5 or 10 employees, it shouldn't take you more than 5 or 10 minutes. It is absolutely worth doing. Know your business, know what's happening. No sooner than later. It's important. Don't just leave it to your office manager to do it. It is your responsibility. If the pay stubs aren't right, it's $50 for the first wrong pay stub, $100 for every pay stub after that, up to $4,000. Unpaid wages, exponential damages and penalties. PAGA is a whole nother category of penalties that they'll throw at you if they hire a lawyer. Waiting time penalties that basically say if you haven't paid for everything you owe that employee no later than their last day of employment, that employee gets paid a full day of pay for every single day that you haven't paid them all the wages you owe to them for up to 30 days. So if you have a hygienist who's earning $400 a day, And 6 months later, she files a labor board claim saying, hey, I was daily per diem, I didn't get overtime. Not only is she going to get all those penalties I've talked about, she's going to get $400 times 30 days, $12,000 just in the waiting time penalties, never mind all the other stuff. If she hires a lawyer, then she gets all of her attorney's fees also. These are incredibly expensive mistakes, incredibly expensive violations. Don't do it, fix it. If we need to talk, let's talk. We'll figure out how to get you transitioned over. These mistakes are just too dangerous and expensive. All right, alternative work week schedule. If you have a dental practice that only works less than 5 hours a day, less than 5 days a week, so usually 4 days a week, sometimes 3 days a week, but you work longer days to sort of make up for the production. You may say we work 4 9s and then we're off every Friday. You can have what we call an alternative work schedule election by which employees approve your proposed alternative work week schedule that says, in the example I just gave you, we agree that we're going to work 9 hours per day, 4 days per week, and that will all be straight time wages, not overtime. And that's our regular work schedule. So let me get into weeds on that a little bit. It must apply to either your entire office or what they call a work unit. So it can apply to all hygienists. It can apply to all chairside assistant. It can apply to all front office, but it can't be pick and choose a person. It can't be this one back office person works longer than everybody else. It can't be this one front office person works longer than everybody else. It applies to a work unit or the entire practice. You can also say back office works 8.5 hours. Front office works 9 hours. We have 2 different times depending on your role. That's perfectly fine. Here's the most important part that people get wrong. It must reflect what their actual regular schedule is, meaning if you have a 9-hour alternative work schedule, that means your employees work 9 hours, not 8 hours, not 8.5 hours, not 8 3/4 hours. It means they regularly work 9 hours. It cannot just be an insurance policy against overtime. So when you're thinking about doing an alternative work schedule, I want you to actually take maybe 3 months worth of time records. Figure out what are they really working. Don't just guess. Don't just say, yeah, I think they all work 9 hours. Let's do that. Look at the time records. Make sure that we're doing it so that it's right. Because if you do it, you do everything right, but it turns out that's not what they're actually working, the whole thing is thrown out. And you owe overtime for every minute over 8 hours in a day because it wasn't their regular daily work schedule. So they must be regularly scheduled, permitted to work the full 9 hours. If they don't, then it doesn't mean that there can't be on occasion they don't work 9 hours, right? Even on an 8-hour schedule, people don't work exactly 8 hours every single day, but it's on average, it's 9 hours. So it can be 8 hours and 55 minutes one day, 9 hours and 5 minutes the next day. But if you look at it across the board, it's 9 hours. Otherwise, overtime is due for everything over 8 hours in a day. For dental practices and most businesses other than basically hospitals, maximum per day is 10 hours. I hope you're not working your folks 10 hours a day in a dental office. That's just an incredibly long, difficult day. But if you are, that's perfectly lawful. 10 hours max per day, 40 hours max per week. You must follow certain procedures in order to implement it. You must have a written notice that says certain things. You must hold a meeting, distribute that notice, explain it, answer any questions people have. Then 2 weeks later, or more than that, but not less than that, because they're supposed to have time to think about it and talk to their union representative, you hold a secret ballot election. Ballot has to say certain things. Employees must approve it. At least 2/3 of the employees in that work unit must approve it, not just a simple majority. Third requirement, you must send a letter to the DLSR, the Department of Labor Statistics Research, that says certain things. Those 3 things must happen. If they don't happen, it is an invalid alternative work week schedule. Even if you think you've been working one for all these years, if you didn't do those 3 things, all 3 of those things, it was not valid. By the way, that letter must be sent within 30 days. I recommend a 4th thing, which is having everybody sign an acknowledgement that just says, I understand we have an alternative work schedule. I understand this is what it is. That way new hires understand right from the start what the deal is. If any step of the 3 steps is skipped, you don't have an alternative work schedule, and someone can go back 3 years with the labor board, 4 years if they file in court for all of that back over time. All right, so that's it for this section. Do we have questions?
Yes, there are questions. At the same time, while we do the questions, I'm also going to put up the second attendance poll.
Fabulous.
So if everyone can just answer that real quick. Let's see, the first question for hygienists overtime, can it be paid only if they exceed the 40-hour work week rather than the 8-hour day? I think you did cover that, right?
Yeah, great question, but no. In California, overtime is over 8 hours a day or 40 hours a week. Many other states it's just 40 hours a week, but we here in California have daily overtime rules.
Okay, perfect. As far as calculating overtime, how much leeway do we have? 5 minutes, 2 minutes? I don't want to have to babysit the clock in and clock out to avoid overtime pay. What are your thoughts?
Zero. There's no leeway whatsoever. If they have 1 minute of overtime, it is overtime.
Okay. Regarding exempt employees, all employees, exempt employees currently clock in and out on a time clock. The time clock lists the employee's regular time and overtime. Should the business be recording the exempt employee's time on their pay stub or just list the 80 hours of quote unquote regular time?
Again, great question. The pay stub requirements of the hours worked and the hourly rate of pay is for non-exempt employees. So if your associate dentist is properly classified, paid that base salary, then no, they don't clock in and out, and their pay stub just shows their base salary. Of course, if there's production pay, it'll show some other things, but no, you're not required to put the time in. And we generally do not have bona fide exempt employees. We do not have them clocking in and out usually. You can if you want, but we don't usually.
Okay. Can an owner dentist be an exempt employee?
Yeah, so owner dentists can be anything they want. They can be unpaid entirely. They can be salaried. They can do anything they want to with themselves. You will be exempted. Remember, I said the owner, the owner, the owner's spouse, parent, or child are exempt from all of these rules.
If we work 10 hours a day, is a 30-minute lunch okay, or do they have to be allowed a 60-minute lunch?
So lunch breaks never need to be more than 30 minutes. If an employee works more than 10 hours, a second meal period is required, 30-minute meal period. If they are not going to work more than 12 hours, then there's another waiver for a second meal period where the employee can choose to skip their second meal period as long as they took their first meal period and they're not going to work more than 12 hours. I hope nobody's working more than 10 hours a day in a dental practice.
Okay. We have a couple more questions before I ask them. The attendance poll is up right now. Folks, there's some people that haven't answered that yet. Keep in mind, you have to answer 3 out of 4 to get your CE. We're announcing them now, so please be sure to do it. It will end in about 30 seconds. Anita, the next question is, I pay my hygienist whatever is higher, $40 an hour, $450 a day, or 35% of production. They almost always get 35% of production. I do have them clock in and out though. If I pay per hour, how do I classify the pay when I do payroll through ADP? They always make more than $40 an hour.
So what I would suggest is give me a call and let's set up a written agreement, a written contract. And basically what that's going to say, it's going to be simply a semantics change, honestly. And so the way we're going to draft it is that the employees paid $40 per hour every day, period and subject, no matter what. They paid $40 per day. They will then be paid 30% of production for everything that's in excess of $40 per hour. Now your $450 per day guarantee, I don't really know where that falls in, and that's going to cause a little bit of a problem. So I'm going to suggest that we not have that. If that means that you're going to pay them $50 an hour instead of $40, we'll kind of figure that out. But if we can do it so that they're paid some hourly rate, and then they're paid the 35% of production for everything that's in excess of that hourly rate, that's the way you do it. Now, in a few minutes, we're going to talk about what we call regular rate pay, because overtime is due based on all wages earned. It's not due just based on the hourly rate. So if somebody's earning an hourly rate and production, and they work overtime, you are required to pay basically overtime on the bonus, overtime on the production pay. So I'm going to talk about that in a few minutes, and we'll go through how that calculation works.
Perfect. That's it.
Sounds good. Okay, and Doug just asked me to answer the questions regarding the COVID. Doug, I don't remember what those questions are. Would you do me a favor and either put those into the chat, into this Q&A, or if you can email those to Andrew so he'll have them in front of them. I am very glad that you brought that back up, and I'll be very happy to answer them.
Perfect. All right, I think we're all set.
All right. So, potential legal claims. You may get in the mail any number of documents, which will be very scary and for very good reason. Of course, you might actually just be served. You may have a process server walk in and serve you with a summons and complaint about a lawsuit that's been filed, but chances are you're going to get something before that happens. So chances are you're going to get an attorney letter saying, here's all the horrible things that you did, you evil employer, and here's the billions of dollars that we're going to come after you for. So let us know if you want to try and settle it before we file our lawsuit. That's usually the first thing that you'll get, letting you know that there's something coming. You may, however, just get a labor board notice. It's called a notice of claim in conference, that basically says your employees filed a claim with the labor board. Before we take this to hearing, we're going to hold a conference on this day and at this time. And the purpose of that conference is basically to go through the employees' complaints. They get to tell their story, go through your responses. What's your story? And we're going to see two things. Number one, does the employee have a claim that they could go forward on? Who's ever right or wrong, who's ever, telling the truth or lying, that's not the issue here. The issue is there a claim? So for example, if an employee said, I'm filing a meal period claim because my meal periods were short. We were scheduled for an hour, but I only got to take 30-minute meal periods. In that conference, the labor commission is going to say to the employee, you don't have a claim. The legal requirement is for a 30-minute meal period, and you got 30-minute meal periods, so you don't have a claim. There's nothing to go forward on. If, on the other hand, the employee says, during my 30-minute lunches, I was constantly having to answer the phone, and the dentist says, no, they weren't. They never had to answer the phone. That's an argument over who's right or wrong, but claiming that I had to answer the phone during my lunches is a claim that can go forward. So the first thing we do at a conference is the hearing officer figures, the labor commissioner figures out, is there a claim that could go forward? If there is, then that person says to both parties, do you want to try and settle? Can we settle today? So the employee says, I want this much, and you say, I'll pay that much. And if you can get to a number that works for both of you, you settle the case is closed, you pay the money, and everybody goes about their life. If not, then what happens next in the labor board context is there's a complaint that's actually drafted whereby the labor commissioner helps the employee to do it properly. Because when the employee does it, the notice of claim and complaint you get, it may be kind of a mess and you can't really even tell what's right or wrong because the employee didn't know how to do it. The amended complaint then, or the complaint is then amended to have all the correct things. So let's go back to our handout for just a minute and take a look at some of these items, examples that I've given you, just so you have a sense. And yes, I am trying to scare you in case you're wondering. All right, on page 20 of your handout this is an actual attorney letter that we got. We get these all the time, by the way, for dental practices and other clients. This is just a very typical one that we got a few years ago. That was for a dental practice it was a front office person. And so she basically said on this page one, these little 4 paragraphs of the factual summary. This is her whole story. This is the whole story. It's all kind of like, there's no real facts here, right? It just says, oh, you didn't pay her all of her wages, and she couldn't take her rest breaks, and she couldn't take her meal periods, and she's owed overtime because she wasn't paid properly. So boom, on pages 21 and 22, here's where me, plaintiff's lawyer, has calculated all the damages that we can come after you for. And on page 22, we see that adds up to $41,000. Basically what that's telling us is that the employee wants to settle the case for $41,000. That's an opening offer. So we go back, we try and negotiate, see if we can get to a number that we settle. If not, that lawyer theoretically is prepared to file a lawsuit. That's what a lawyer letter looks like. Do not delay if you get one of those. Call TDIC and get a referral to a lawyer. Call me. Call any other employment lawyer who you work with. Get yourself to an employment lawyer to talk about, what do I do? How does this work? When you get these letters, or before you get these letters, we talked about this last month, you will also usually get a demand for records, a demand for the payroll and time records, a demand for the personnel records. Time and payroll records must be produced within 21 days of getting a request for them, whether it's from the lawyer or the employee. Personnel records must be produced within 30 days of getting that request. Once you get those records out, usually this is the letter that follows from producing those records. The other item that you might get is a notice of claim in conference, which I mentioned. It is a sample of that is on page 23. So in this example, we have an individual who's filed a claim. This person was a hygienist, paid $55 per hour. By the way, she's actually paid $50 an hour, but that was all part of what we fought about. She's claiming she was daily per diem. So she's claiming overtime, reporting time pay, because she's basically saying that she got docked when there was patient cancellations, and that was midday while she's sitting around waiting for the next patient. So that's falls under a category called reporting time pay, meal period pay, rest period pay, unreimbursed business expenses, but she said she had to buy her own scrub. She said she had to use her own cell phone, and waiting time penalties, because of course, whenever you don't have the proper final paycheck that includes all wages owed, including back overtime, back wages, back whatever it is, then you get waiting time penalties. Now, here's what I want to point out. On page 26, so in this case, we went to the conference. That hygienist happened to have a lawyer with her. My client, of course, had a lawyer with them. And the hygienist was just like super high drama. Like, here's all the horrible things that happened. And here's why you owe me a whole ton of money. We didn't settle. And so then the lawyer and the hygienist stuck around. She didn't have a lawyer when she filed the original claim, by the way. So then they stuck around, and the labor commissioner helps them fill out the complaint properly. Well, as you see on the bottom of page 28, that claim, which started out as a $43,000 claim, became a $94,000 claim, because that's how helpful the labor commissioner was. So, and they added on some claims for liquidated damages, which is just an extra penalty, and for not providing the payroll records on time. But for the most part, it was really just a labor commissioner saying, oh, silly you didn't calculate all the penalties. Let me help you with that. So it all gets so expensive. It is so dangerous to make these mistakes. I implore you to really think seriously. If you're not doing things right, really take a hard look at, am I willing to take this risk? And maybe the answer is yes. Maybe your folks have been with you for 20, 30 years. You're just not going to make a change, in which case, maybe there's some things you'll change. So for example, my front office person has been with me for 30 years. If I tell her I'm changing her to hourly, that's probably going to cause her to file a claim against me, because she's going to be so angry. It's going to feel like a demotion. There's no way I'm doing that. I get that. I hear you. You need to make that decision. If, however, I can convince you to just have that office manager start clocking in, that's going to mean that she can't estimate her own time. It means that if she's not really working overtime, there's going to be no overtime claim. It means that hopefully you'll be able to demonstrate that meal periods were being properly taken. If meal periods are properly taken, that just helps out in the general concept of rest breaks. So at least have folks clock in and out. I am not trying to tell you if you haven't clocked it out, your problems are solved. They are not. I'm telling you that if you just refuse, I am not going to make the changes. I'm going to have my hygienist stay on daily per diem. I'm going to have them stay on production-based pay. I'm not going to change it. At the minimum, have your folks clock in and out. Non-exempt, not, how do I say that? I'm not saying that your exempt folks should clock in and out. They do not need to, probably should not. I am saying that your non-exempt folks should all be clocking in and out. Even if you make the decision, you're going to continue to take the risks and not change how they're being paid. All right. If you receive any of these documents, don't delay, contact legal counsel. If you have an attorney who's a general business attorney, I'm going to very strongly suggest that you don't just rely on what that person says. Just as some general dentists may think that they can do root canals, chances are an endo does them better. Some business litigation attorneys think they can do employment law. Trust me, employment lawyers do it better. I'm sorry, I'm not going to go to a general dentist for my root canal. I want my endo to do it. I'm going to ask you to think about that in the context of your attorneys. Go to your specialist attorney for what your specialist is. I don't care if it is, of course I care if it's me. I'd love for it to be me, but whether or not it's me, talk to an employment lawyer. All right. I saw that a question popped up. Andrew, is that question about what we've been talking about, or should I continue on? Oh, should an associate dentist clock in and out too? No, as long as they are properly classified as exempt. So in the first hour, we talked about that quite a bit. Associate dentists paid a minimum base guaranteed fixed salary. No, they do not need to clock in and out. All right, next topic is paid time off. So we're going to talk about vacation and PTO, and we're going to talk about paid sick leave. We're going to start with our discussion of vacation and PTO. In reality, vacation and PTO are the same thing, legally speaking. There are certain rules that apply to vacation. The exact same rules apply to PTO. There are certain rules that apply to paid sick leave. Those are different than the rules that apply to vacation and PTO. In the real world, as opposed to the law world, We think of PTO as basically being a bank of benefits that combines vacation and sick leave into one. Personally, I love the concept of PTO. It is easier to administer. It feels like a better employee benefit because it's not just, if I don't use my sick leave, then I forfeit it, whatever. It's a bank of benefits that says, employees, we want you to take time off for yourself, for rest, relaxation, vacations, clean out your garage if you want, whatever, take time away from work. So we're putting it all into a bank called PTO, use it for whatever purpose. And if you're sick, it is all there for you for sick also. It's there for whatever you need it for. Vacation says, we're going to give you paid sick leave separately that you use for sick leave purposes. You cannot use paid sick leave for vacation. You can only use it for paid sick leave. Vacation benefits you can use for vacation. You can use vacation benefits also for sick leave because you can use vacation for anything. Law says vacation can be used for any purpose. So vacation and PTO, to the extent that I use those terms interchangeably, just keep in mind, they mean the same thing for my discussion here. So you are not required to give any vacation pay whatsoever. You're not required to give any PTO pay. You're required to give paid sick leave, but you're not required to give anything other than paid sick leave. If you choose to, most employers and certainly most dental practices do provide some vacation and or PTO benefits. If you don't, I will suggest to you that you are probably not compensating compensating as a broad term, your employees competitively with the market. The market in the dental world pays vacation pay to all employees, with the exception of dentists. Almost never do dental practices pay associate dentist vacation. And I'd say less than half the time do dental practices pay vacation time to hygienists. If they do pay it to hygienists, it's usually to hygienists who are either full-time or close to full-time. If you do, fabulous, good for you. Again, you may be more competitive in terms of paying better benefits, and I applaud you. I love the idea of vacation PTO for employees, everybody. But if you're not paying it to hygienists and dentists, you are in good company. Many dental practices don't. They're highly paid. They can take their vacation and PTO time unpaid. The concept of vacation pay under the law is that vacation pay is like wages in the sense that it is earned like wages are earned. So when you think about asking questions to yourself in terms of, can vacation pay be forfeited? Can I tell employees they have use it or lose it? Can I tell employees that they can't, they don't get it till the end of the year? Ask yourself, can I do that with wages? The answer is no. If you can't do it with wages, then you can't do it with vacation pay. It is treated like wages earned, and all the same kinds of rules apply. So for example, if you say after 1 year, you get 1 week, that's fine. But what that means is that they were earning that week all year long. If you want to have a policy that says you can't use it for 1 year, that's fine. You can do that. But they were earning it all year long. So if you fire an employee at 2 weeks, whatever they've earned in 2 weeks, maybe 1 hour, you owe them that 1 hour of vacation pay. Pay it to them on the final paycheck. If you want to have a policy that says you earn it all year and you can't use it till 90 days, that's great, but they're still earning it. Now, you can have a policy that says you don't begin to earn it until 90 days or 6 months or 1 year. That's fine too, but you then cannot have what you would consider to be a catch-up. So for example, if an employee works 40 hours a week, and they earn 1 week per year, so they earn 40 hours a year. But you say it doesn't start to accrue until the 90th day. That means that for 1/4 of the year, they were not earning it. For 3/4 of the year, they were earning it. Therefore, at the end of that first year, they earned 30 hours, not 40 hours. You cannot have a catch-up. You can say they begin to accrue it from the first day of work, in which case they will have earned 40 hours. So either way is fine as long as you're implementing it lawfully and properly. Okay. Why am I not scrolling through my screen? All right, so they accrue. You can have PTO or vacation basically provided to employees in one of 3 ways. The most common way, and the way that I recommend, is what I've just explained. It accrues all year as they work. Another option is you can front load it. And some people do this. You can front load it and say on the day you begin work, you have 40 hours of vacation pay. You can't use it for 90 days, but you have 40 days of vacation pay. You can do that. But once they have been provided that pay, it is there, those benefits, it is theirs to keep, may never be taken away. If you fire them on the second day of employment, you have to pay them all 40 hours because you already gave it to them, just as if you'd given them a signing bonus, right? They've already got the signing bonus, they get to keep it. If you fire them, that's on you, they get to pay. So we almost never front load. Some dental practices do, some of my clients do, but we almost never front load vacation or PTO. Backload, if you do it, it's unlawful. You cannot say at the end of the year you get 1 week, at the end of 2 years you get 2 weeks. They've earned it as they go. You can have a waiting period before they use it, but they accrue it as they go. So 2 lawful ways, third way is unlawful. You cannot have a user lose it. You can't say if you don't use it at the end of the year, it goes away. That's illegal. Once they've earned it, it's theirs. But you can have a maximum cap that says you earn 1 hour per pay period, and we have 24 pay periods in a year, so you've earned 24 hours by the end of the year. You can have a maximum cap that says the maximum cap is 48 hours. So if you ever get to 48, it's going to freeze. You will not earn any more until you use some of it. So it's not a user to lose it. They're not losing anything. There's just this cap. So oftentimes what we say is the cap is equal to whatever your 1 year accrual is. If you accrue 40 hours, your cap is 40 hours because we want you to use it. Oftentimes we make that cap 2 years. We want you to have time, plenty of time. And when we're busy, you want to take a week off, we don't have time. A lot of people say, we don't have time right now. How about in 6 months, whatever. So we make the cap whatever you want it to be. We like having a cap. We don't want it to accrue forever for employees who never take time off. And we want employees to take time off. Let me take a minute to talk about that. I understand that many dental practices work basically with staff that they need. We don't have a lot of extra. We don't have a lot of fluff. Therefore, when somebody's off work, it's a hardship. It's difficult. I understand that, but I want you to take a step back and think about the reality of human beings needing time away. And I want you to think about the reality of your practice needs to be able to function without that person. If you know that people are going to be taking vacations, they're going to be gone for periods of time, that will encourage cross-training. That will encourage people to know how to do each other's jobs to a certain extent. If you have a back office assistant who's going to be out and there's nobody else there who can do it, you need to bring in a temp for that week. Bring in a temp for the week. There are ways to get temps. There are referral agencies that will send you temps. Bring in a temp for that week. Part of the reason that I say it's good for the office is because that is when you discover things that you wouldn't otherwise discover, particularly with the front office. I'm so sorry about the frog in my voice this morning. Now there's something in my eye. I'm kind of going crazy here today. Front office, when they are gone, you discover all sorts of things. Let me give you some examples. One example was that's when the employees all started joking about, oh, Sally's not here. That means the vodka is not coming out at 1 o'clock because on Thursdays, the dentist would leave at 1 o'clock and the employees had the rest of Thursday as no patient day in order to do all the paperwork, all the restocking, all the inventory, all the cleaning up, get ready for the next week. And every Thursday when the dentist would leave at 1 o'clock, front office person would pull out the vodka. Dentist only found out about it because he overheard the employees joking that we're not pulling out the vodka this Thursday because Susie's not here. Really important thing to know. That's when you find out about embezzlement. That's when phone calls come in that are very strange and don't make any sense. And the reason they didn't make sense is because money came in that you never got. I've had clients who've had employees who applied for care credit loans for dental treatment that never occurred and the employee took the money. I had a client who had a front office person who actually had a whole separate bank account at a different bank in the name of the practice, and she would funnel some of the insurance checks to that bank account, which the doctors were signed on to, except it turned out it wasn't their signature, it was her signature. And they only found out about it because while she was gone, a bank statement happened to come in the mail. She slipped up and made a mistake, forgot bank statements would come in the mail while she was gone. And the doctor called bank to say, we don't have an account there. Of course you have an account here. You've had an account here for 3 years. That employee had embezzled hundreds of thousands of dollars from that practice. In fact, that practice was on the verge of bankruptcy and they couldn't figure out why they were so broke. That employee went to prison for a couple of years for embezzlement. They only found out about it because she was gone from the practice. So human beings need time away. Businesses need employees to be gone. In fact, you may know that it's a law in banks. Employees must take 1 week vacations required by law, because that's when you find things out. So I encourage you to encourage employees to schedule time off, be gone, and the best way to do that is providing some of the vacation pay for them to do that. All right. That's it for my soapbox for sick leave. For vacation and PTO. Paid sick leave, whole different thing, whole different set of rules apply. I know it's confusing. I want you to think about vacation pay as wages. If the rule would apply in wages, it applies in vacation pay. Sick leave is very different. So sick leave, and of course, since 2015, we have paid sick leave laws. So paid sick leave laws tell us the following. There are 2 ways to give paid sick leave. One is that you front load it. I call it granting. I don't know why I came up with that term before they started calling it front loading. So you grant it or front load it up front. The second way is it's accrued. Remember, we talked about how it accrues over time as they work. So paid sick leave can accrue or be granted up front. Granting up front works as follows. You must grant up front not less than 3 days or 24 hours. The reason that may be different is because if you have an employee who works 6 hours a day, then 24 hours is the greater of. If, on the other hand, you have an alternative work schedule and employees work 9 hours a day, 3 days is 27 hours. In that scenario, 3 days is the greater of. So if you're granting or front loading, it must be the greater of either 3 days or 24 hours, whichever is more. Must be granted on the very first day of employment. So the day they start work, boom, 24 hours or whatever it is for 27 hours in the bank. You can have a 90-day waiting period, so they can't use it yet, so it's not available. In fact, what most paycheck stubs are now doing is it shows sick leave benefits, 24 hours. Sick leave available, 0 or 24, whatever's available. So they're showing both. Must be granted on the first day of employment and every year thereafter. So if you're doing it on an annual basis and you're going to run it from the anniversary date, so then on their first day they start work, they get their 24 hours. I'm going to use that as, I'm just going to keep saying 24 hours. On the 1 year anniversary, they get 24 hours. On the 2 year anniversary, they get 24 hours. You can set a different date for them to get it. For example, many employers, if not most, do it on January 1st. That's fine, but on the day they start work, they get 24 hours in the bank. And then they get it every January 1st thereafter. So if they start work on September 1, they get 24 hours in the bank. You want to do it on January 1, that's fine, but on January 1, they get 24 more hours in the bank. Paid sick leave benefits, as long as they are only permitted to use it for sick leave purposes, do not have to carry over if you front load. So you can front load 24 hours. If you haven't used it by the end of the year, you can have a use or lose it policy for paid sick leave. If you haven't used it by the end of the year, it goes away and boom, you're front loaded 24 hours. The bank starts over. What many dental offices do is they grant these 24 hours up front and they choose to cash out unused paid sick leave at the end of the year, which serves a couple purposes. Number one, makes it less likely that an employee is going to call out sick when they're not sick. Because if an employee feels like, hey, I'm going to lose my sick leave if I haven't used it by the end of the year, and that's my benefits, I'm not going to lose it, they'll call out sick whether they're sick or not. Solves that problem. Number two, it's a bonus. It's a way for employees to be like, oh, if I don't call out sick, then at the end of the year, if I'm making, I don't know, if I make $400 a day and I don't call out sick for the 3 days, I'm going to have a $1,200 bonus at the end of the year, which I can really use at Christmas time. If you're doing it on an anniversary basis, same thing. You can choose to have it be forfeited at the end of your anniversary year. It goes away, or you can choose to cash it out. The benefit of doing that way is it's easier on your cash flow, right? You're not cashing out a bunch of people at the same time. You're cashing out on their anniversary date. So when you're front loading, and I keep saying that because this does not apply to the accrual method. If you're front loading paid sick leave, it can be use it or lose it. It can be forfeited at the end of the year. You can choose to cash it out if you want. Choose not to cash it out if you don't want. It does not have to carry over, except in the city of Los Angeles. City of Los Angeles requires you to carry it over. And I will be honest, I'm not familiar with Northern California rules. I know that San Jose has rules, Berkeley has rules, San Francisco has rules. So I may be not being fair to any of you who are in Northern California. You may have rules that apply to you. In Southern California, the city of LA is the only one that requires you to carry over. It cannot be forfeited. So let's turn, if we will, to the next handout page, insert, which is page 31.
Anita, real quick, I'm going to throw up the next poll right now.
All right, everybody, the next attendance poll is up. So if you're looking at your handouts, be sure to pop your head up for the attendance poll.
Thank you.
And I'll take a break for you to do that.
While we're taking this break, Anita, somebody asked if the employee doesn't work, for example, when they were furloughed for the closures, or if they were on maternity leave, do they still accumulate vacation time?
It's up to you. When I do employee handbooks, the employee handbooks have always said employees do not accrue or earn paid vacation, paid sick leave, or other benefits during any leave of absence. It never dawned on me until March of 2020 that it should say, or during a furlough. So it didn't provide, so I don't think anybody's handbooks, no matter where you got them, provided for furlough. So what I was telling Dennis is during the furloughs, it's entirely up to you. If you can afford to let them have accrued it, go for it. It's a kindness, it's a gift, it's generous, it's a good way to treat your folks. If you're flat broke, you didn't get PPP money, you can't afford it, then you don't have to. Under other kinds of leaves of absences, however, if you have an employee handbook, it should tell you what to do. My employee handbooks that I do for clients make very clear multiple times throughout the handbook, you do not accrue during any kind of leave of absence.
As a follow-up to that question, it says, what would be the advantage for the business to give vacation accrual before the probationary period is over?
The primary benefit, honestly, is it's easier to, when you have a new hire employee, it's just easier to set it up so that they get the paid sick leave from day one, they get their paid vacations, accruing from day one, they do all their new hire paperwork, it's all programmed into the computer, and you're done. It's just easier. It's also nice for the employee to know that at the end of the year, they'll have their full week rather than 3/4 of a week. That's really the only reason. If you want to set it up so that they don't start to accrue it until they're 90 days, that's absolutely fine. Just make sure that you don't do a catch up. Make sure that then at the end of that year, they will have earned 3/4 of a year, not a full year. Okay, on your handout on page 31 is my little cheat sheet. And this is I actually created this for myself because I could not keep straight which cities, which counties had different rules. So I'm sharing it with you so that if you are in the city of Los Angeles, the city of San Diego, Santa Monica, or the city of San Francisco, you know that your rules are different. City of Los Angeles, as I mentioned, requires carryover. So if you look all the way to the right-hand side of the column in my other notes, may only cash out front-loaded if they're in excess of 72 hours, because that's what the city of LA says you must allow carryover up to 72 hours. Okay, so that's our first method of providing paid sick leave benefits, the grant front-load method. I like that method. I think it's easier. I think it's just, again, I'm a fan of easy because the more complicated things become, the more likely there's a mistake. If there's a mistake, the more likely somebody might throw that into the basket of here's all the reasons I'm going to come after you. So that's why I like PTO, right? You put it all into one bank and it's easier. If you're going to do it separately, I like front load. I think it's easier. But if you don't want to do front load, and it's perfectly acceptable if you don't, our other option is the accrual method. So the accrual method says, by law, sick leave must begin to accrue on the first day of employment. You have no choice. And it must accrue at not less than 1 hour per 30 hours worked. So a lot of people like this method because it is directly correlated to the hours worked. So whether they're on a leave of absence, whether there's absent for 1 day, whether they're on a holiday, whatever it is, they are not earning their benefits unless they are actually working. And I will tell you, some employers have actually gone to making this their PTO policy. You earn PTO at the rate of 1 hour per 30 hours worked. That way it satisfies both requirements, which I'll talk about in a minute, kind of putting them together into one, what you need to do. So 1 hour per 30 hours worked, Now, the way that shakes out, I'm just giving you some examples here so you have a sense of what this means. If somebody works 40 hours per week, and I'm assuming that there's 2 weeks a year they don't work, whether it's because of holidays, vacation, sick leave, whatever. If they work 40 hours a week, they're going to earn almost 70 hours per year at 1 hour per 30 hours worked. If they work 30 hours a week, they're going to earn 6.5 days a year. If they work 14 hours, which I know is a strange number, but I'm providing it for this reason. At 14 hours, they earn just over that 3 days per year. So if you want to consider it, doing as a front load, what I would say is front load everybody who works 2 days or more per week, 14 hours or more per week. That's where your break even is. If you have somebody who only works 1 day a week, say they only work 8 hours, they're going to earn, if they accrue it, they're going to earn about 13 hours in the year. So front loading 24 hours for them is kind of a bummer, right? You basically lose 11 hours that you didn't need to lose. So when you have folks who are working less than 2 days per week, I would say have them accrue sick leave at 1 hour per 30 hours worked. If they're working more than 14 hours or more than 2 days a week, front load, easy, simple. They get the 3 days or 24 hours, make your life easy. If you want to have everybody be treated the same, so they all accrue at 1 hour per 30 hours worked, fabulous, do it. Put it on the paycheck stubs. That way your payroll service has the computer programmed to automatically calculate the accrual. You certainly don't want to be doing that manually. So if you're going to be doing accrual based on hours worked, absolutely put it into the payroll system so that it just automatically happens. By the way, when you're reporting your payroll hours, you must make sure you're reporting them properly. Holiday pay is holiday pay. That's how it should be reported. Time worked is time worked. Vacation is vacation. Sick leave is sick leave. Don't mix them up. One of the cases I'm dealing with right now, which is a very messy case. It's messy because for one reason, this dentist designated his office manager to be responsible for everything, and she did not know what she was doing. Sick leave wasn't sick leave, it was time worked. Holidays was not time worked. She was reimbursing for uniforms, which was really for insurance. Like she didn't care what category she put things in, which means not only is it very difficult for us now to prove our case that people were paid right, it means that there's a pay stub violation every single payday because none of the pay stubs are right. They're all a mess. So sorry for that little diversion there, but allocate it properly. So when you've got sick leave that's accruing, when somebody's out sick and you're reporting payroll, make sure you're reporting 8 hours of sick leave. That way it comes off of that sick leave bank properly while they're accruing. It also comes off as they use. Okay, so sick leave, if they're accruing, must accrue at not less than 1 hour per 30 hours worked. Here's how the math works out. When you're accruing, it has to carry over. You are not allowed to cash out accrued sick leave. You may cash out front loaded. Here's the concept. The law wants employees to always have some sick leave benefits available unless they've already used them. If you have them accrue and then you cash out, they're starting that next year with 0. And then they'll eventually have 1 hour. And then they'll eventually have 2 hours. And the law does not want that. The law wants them to have paid sick leave benefits in the bank unless they've used them. So with front load, you're allowed to cash it out because at the moment you cash out, you're reloading the next year. Accrual, once you've cashed it out, they don't have anything available. All right. You make, even if they're accruing at say 8.5 days per year, you're allowed to have a max cap, but they're only allowed to use 24. You can have a max per year. You can allow that there's a max cap of 48. So if at any point they hit 48, it caps. It's not a per year cap. It's just a 48 hours cap. All of this is confusing. There's a lot of numbers being thrown at you. Let me offer you 3 options. One option is A, do it this way, program it all onto your paycheck stubs. And even though all this stuff is very confusing, you don't have to think about it. It'll all be calculated and shown on the paycheck stubs. You will then only have to monitor the paycheck stubs so you know what the status is. It's one option. Another option is front load your sick leave. It is easier. If they have it available, they can use it. If they don't have it available, they can't use it. If you want to cash it out, cash it out. If you want to have a use it or lose it, do. You don't have to worry about all these numbers. The only number you have to worry about is front loading the greater of 3 days or 24 hours. So that's the second option for how to provide it. Third option for how to provide it. You combine your vacation and sick leave into one bank of benefits called PTO. PTO can be used for any purpose. Here's the hitch with PTO. If you're going to use it as both vacation and sick leave, then it must meet all of the requirements of both. Therefore, if you're going to have PTO accrue, it must accrue at not less than 1 hour per 30 hours worked. So you can have a policy that says everyone gets PTO at 1 hour per 30 hours worked. You're all good. You can also have a policy that says you're going to, let's take the 40-hour example. As you can see, the 8.5 days is almost 2 weeks. 2 weeks would be 10 days in that example. So you can also have a policy that says everybody accrues PTO beginning from the first day of employment at 2 weeks per year, right? That satisfies the 1 hour per 30 hours worked. It actually exceeds it. We're not going to have a cap that's any less than 1 year's accrual. By law, you can't. So you're going to easily hit that 40-hour cap. You don't care how much of it they use. It's entirely up to them to use whatever they want to use. You're never going to forfeit it. You're never going to cash it out. You're never going to have a use it or lose it. You're going to have a maximum cap, but other than that, they just need to use the PTO for time off. Hopefully, because it's PTO, and what generally happens is people schedule time off rather than calling out sick when they're not really sick, because they know they're using their PTO and they kind of want to save that for vacation. Here's the downside of PTO. The main downside, in my opinion, of PTO. Remember the rules for vacation. You can never forfeit it. Therefore, when an employee leaves your employment, you must cash out everything they have in the bank of vacation. You are not required to cash out sick leave. Therefore, when an employee leaves your employment on the last day, you are not required to cash out their paid sick leave. PTO must satisfy all the rules for both, which means if an employee leaves your employment, you must cash out everything that's in the PTO bank, which is now going to include the vacation and sick leave because we put it all into one bank. For me, if you're in financial straits, that's not going to work for you. You need to have separate policies so you're not cashing out any more than you have to. To me, if you can afford to do PTO, combine it all into one, make your life easy, it's a preferred benefit for most employees, go for it. If you want to keep them separate because you like to front load and you like to cash out unused, I love that as a second choice. I think that's a great option for many, many dental practices, many employers. So I know I've thrown a whole bunch at you. Here's some things that apply to sick leave no matter which method you choose. You can restrict the use till the 90th day, and we generally do that for vacation also. It applies to every single employee. So paid sick leave is required for every single employee who is going to work 30 or more days in a year. That doesn't mean it applies after they've worked for 30 days. It means if they are going to work 30 days in the year, you must provide paid sick leave. How do you know if they're going to work 30 days? You don't know for sure, but you just base it on their schedule. If a hygienist comes in every other Saturday, that means she's going to work 24, 25, 26 days in the year. You do not have to provide paid sick leave. If that hygienist comes in every Saturday, she's probably going to work 50, 48, 49 days in the year. You must provide paid sick leave. It includes dentists. It includes hygienists. It includes temps if that temp is going to work at least 30 days. So let's say your practice is open 3 days a week, or you're going to have a temp work 3 days a week. And if that temp is there, then is then there with you for 10 weeks, that's 30 days. That means you were required to provide paid sick leave, which means it goes on the paycheck stub, shows that they have the paid sick leave benefits. It's not available yet because it's not available to the 90th day. And if that temp works 10 weeks at 7 days per week is 70 days. That's how we count that for those purposes. They're not going to hit the 90th day. They're not even going to have it available, but nevertheless, they have the paid sick leave. It's just not available yet. I know it's all confusing. Must track it on paycheck stubs or some of the writing that you give every payday. The payout is much more complicated if you're not paying base salary, if you're not paying base hourly, if you're only paying based on production, then paid sick leave, you have to take a look back at what did they earn and how many hours did they work And how does that divide out? And how are they paid for the sick leave? It's gnarly. I hope I've already convinced you to pay all exempts a base salary, pay all non-exempts a base hourly. That way the sick leave payout, another benefit is the sick leave payout can be based on that as long as we've written the contract properly. Any questions on that topic? One of my employees is working from home to do the billing. Am I required to pay paid sick leave? Absolutely. They are working, they get paid sick leave. If they voluntarily quit versus terminated, where'd that one go? Oh, here. Do we need to cash out the benefits? You must, no matter how they leave your employment, furloughed, but not furloughed, laid off, quit, fired, no matter how they leave your employment, you must pay all vacation pay because it's like wages. You must pay all PTO because it's like wages. You do not have to pay out paid sick leave as long as you only ever allow them to use paid sick leave for paid sick leave purposes. If you let employees use paid sick leave for other purposes, then by law, you have converted it to vacation and you must pay it out. So paid sick leave may only be used for paid sick leave purposes. All right, other hot topics, and we're almost at 11, so I'm going to race through these. Working interviews. I know you dentists love to do working interviews. Legally speaking, that person is an employee. Even though they're only with you one day, they are an employee. So at the very least, I want you to put that working interview in writing. I'm going to pay you $20 an hour. You're going to work from 10 to 4. Give them a paycheck or a check that very same day for those 6 hours or 7 hours or whatever it was. Give them a lunch break. In fact, that's a great time to take them to lunch, get to know them a little better, chit chat, sitting outside somewhere safely distanced. But they are working that day, so must be paid. Probationary period. People think that they can fire on day 89, but they can't fire on day 91. There's no such thing. People are always on probation. They're at will. You can always fire them for a permissible reason. You may never fire them for an impermissible reason. We talked about that in some detail last month, but probationary periods aren't really a thing. With that said, it's a psychological thing. So I certainly encourage you to terminate prior to 90 days if you can. When you terminate, you must pay all wages on the very last day of work, no matter what. So if I'm firing you, if I'm laying you off, I must pay you all wages on that very day. Temps. When you hire a temp, by definition, that means that person is going to be temporary. You are hiring them to cover leave of absence. You are hiring them to put all of your paper files onto the computer. You are hiring them to cover somebody's absence. A temp is not someone who you've hired and you're just checking, having them be a temp while you figure out if they're working out. That's not a temp. That's an employee. They may be during their introductory period or probationary period, even though it's not a legally defined thing, but they are an employee. All benefits apply, all rules apply, all non-exempt rules apply, it all applies. Reimbursable expenses. You must reimburse employees for any expense that they necessarily incur. So if they have to purchase a special scrubs, you require everybody wears black scrubs. That is a special set of scrubs. You must pay them for those. On the other hand, if you just say, wear scrubs, I don't care what color, that's not considered a special uniform. You don't have to pay those. If they're doing any driving for you, they're driving to the lab to pick something up, they're driving to referral dentist offices to drop off gift baskets, whatever, must be reimbursed for mileage. IRS standard rate is what we recommend. If they're using their own personal device for anything related to work, if you are text messaging with your employees, if they're using their computer from home for any reason, your front office is doing scheduling, whatever, you must reimburse them. Talk to me about how that works if you're in that situation. And again, I really discourage you from text messaging with your employees. If you need to talk to them, talk to them. Communicate, not text message. And certainly don't communicate after hours if you don't have to. That is all time work that must be paid. All right, weighted average. If an employee is paid at more than one rate during a pay period. So the example I gave you was a hygienist who's paid $50 an hour when she's working, and you're going to pay her $25 an hour because you brought somebody in to teach a CPR class. That's perfectly lawful. Must be in writing ahead of time what that lower rate is. Must be in writing ahead of time what that lower rate is. And if that employee happens to work overtime during that work week, then the way that you have to calculate the overtime is you either pay the employee at the higher rate, so you pay overtime at the $50 rate, or you figure out the weighted average. how many hours at $50, how many hours at $25, add that all up together, divide it by the hours worked. That's your weighted average hourly rate upon which you must calculate their overtime. On page 34 of the handout, I've spelled that out to you in detail, how you do that calculation. Regular rate, as I already mentioned in answering the question about how the hygienist was being paid. Overtime is due on all wages earned. So if you pay any kind of a bonus, if you pay any kind of a production pay, so front office gets a $500 bonus if collections for the month exceed $100,000. That means that overtime must be paid on that $500 bonus. Anybody earns production-based pay, collection-based pay, bonus pay, whatever it is, overtime must be paid on that bonus, and there's a way that you calculate it. I'm not going to go into detail because it's kind of a gnarly calculation, but on page 35 is the example. Trust me, you will need, if you're doing this, you'll need to read it a few times, maybe many times, do some practice runs on it, set up an Excel spreadsheet if that's an option, if you really know Excel and you can do that, or have your bookkeeper do it. Your payroll service is probably not going to do this for you. You are probably going to have to figure this out for yourself. So be aware. I love bonuses. I love production pay. I think we human beings are greatly motivated by them. I think I talked about that last month, but you must pay properly. Don't get yourself into trouble by providing those incentives and then not paying properly based on those incentives.
Anita, I'm just going to interrupt for just a quick second. I'm going to launch the 4th attendance poll. That way, if anyone after that poll needs to take off because we are at the 11 o'clock hour, that way people can good. But you're still fine to keep going. At least this way, people can get their CE and be fine.
And I'm 5 minutes from done, and then we'll take all the other questions. So again, just making sure everybody heard Andrew. Last attendance poll is up now, so jump in and answer that. All employees must be provided their compensation in writing. So you have to have in writing what their pay is. We usually do that at the beginning of employment with offer letters. There's a notice to employee form that's required. We talked about that last month. That provides all of that, that fulfills that requirement at the beginning of employment. As employment continues on, if you're giving raises, that shows on the paycheck stub, that's fine. But if at any point you are lowering pay, you must provide in advance in writing. In addition, if you're providing any incentive pay that is based on any kind of a percentage of production, percentage of collections, percentage of profits, percentage of anything, then the law says that must be by a written agreement that is signed by you and signed by the employee. So if you're doing anything along the lines of incentive pay, let's get you onto a written compensation plan that provides for it. Last but not least, in my hot topics, training, meetings, other work-related events. If you are wondering, do I need to pay folks when we go to CDA, for example? The answer is probably yes. Here's why. In order to not pay for somebody, all 4 of the following must apply. All 4 must apply. So attendance is optional. That's usually easy. The event is outside the regular work schedule. So the concept here is if employees normally work on Thursdays and you're going to go to CDA on Thursday, the law does not want your employee to lose wages that they otherwise would have earned while they're working. If you're going to CDA on Friday and you don't usually work on Fridays, then you've met that requirement. No actual work is performed. Again, for dental practices, you've usually met that requirement. There's some other professions and industries where they go to these offsite events, but they're actually, doing work. The problem one is the 4th one. The program is not, sorry, I was just going to say the poll's about to go down. It went down. Hope y'all got it. The program is not directly related to the employee's current role. That's the tough one. If it's not related to their current role, why would you be doing it? So what I would say is if you're doing things like team building, social events, Christmas, lunch, whatever, you're going to meet all these requirements probably, or you can make sure that you meet all these requirements properly. When you're doing things like going to seminars, that's a little bit more of a problem because that 4th requirement may be a problem. When you're doing these kinds of events, even if you're paying for the time, you don't need to pay for their free time, but you do need to pay for their commute time. Remember I said there's 2 times when you pay for commute time. One is when they're doing on-calls and having to commute back to a work site. The second one is when they're outside of their normal work day and commuting to an event, you get to pay for their commute time. Remember when you're doing those kinds of things, overtime rules apply. So if going to that event on that day results in more than 40 hours a week of work or over 8 hours in that day, overtime is due. If you want to pay them at a lower hourly rate for these events. Remember, we talked about you can do that. Then overtime must be calculated at that weighted average rate if they're more than 8 hours a day or 40 hours a week for that time. All right. Last but not least, I always love to close with every program because I'm such a fan. A good employee handbook is a powerful tool. Gives you the notices, communicates expectations, answers questions, helps you to make decisions and answer questions because it's in that handbook. By the way, the handbooks now do say sick leave and vacation do not accrue during furloughs or leaves of absence. It helps you to enforce your own policies. Oh, I'm sorry you didn't follow the policies. See, here it is right in the handbook that you signed. It's evidence of your compliance with the law. When you get a claim, one of the first things I'm going to say to you is send me the employee's payroll records, time records, personnel file, and your employee handbook. I want to see, are your policies in compliance? Are they good? Are they going to help us? And it confirms at-will employment, which we lawyers love everything that confirms at-will employment. All right, so final inserts in your handout. Page 38 describes our employee handbook service. Page 39 reminds you that harassment prevention training is required. Everybody was supposed to have had it by December 31st. If you haven't had it yet, get it. And the last page is simply that I'm co-author of some books. We're getting ready to publish them. If you're interested, let me know. I don't think most dental practices would be interested, but if you love all this HR stuff and really want to have fabulous resources at your fingertips, and I help write them, so I think they're fabulous, I strongly recommend these books. All right, let's see what we have in the Q&A.
Anita, before you answer those questions, I just want to mention that a couple of things before people start signing off here. I've put a link in the chat with a post-event survey. Anyone fills that out, it'd be really, really helpful. CE certificates, for those of you who answered at least 3 out of the 4 poll questions, those CE certificates will be emailed out next week. If you did not answer 3 out of the 4, I'm sorry, but you don't qualify for CE. That's just a state requirement. And then lastly, there will be this video or this webinar is being recorded. And that recording video will be emailed out to everybody as well as out to all of our Phillips Accountancy clients sometime next week, probably Friday of next week. So Anita, I'll let you take it away.
Thanks, Phil. Thanks, Phil. Thanks, Andrew. I will tell you that it does generally take us about 2 weeks to get those certificates out to you. Andrew has to go through every single person and determine, do they get the poll questions and then put in their email address, and then he emails over the spreadsheet to us, and then my assistant, when she's not busy assisting me, puts together all the certificates and gets those emailed off to you. So be a little patient with us. It does take us a couple of weeks usually to get those off to you. All right, from last webinar, what is considered excessive absences? There's no black and white answer. What I usually do when a dentist tells me that there's excessive absences is I ask you to send me the list. What day were they absent? Why were they absent? And then we take a look at that to determine, number one, was it an absence for a legally protected reason? Paid sick leave, I have a disability, I have a serious health condition, some other legally protected reason. We want to be very aware of what those are. Or did they just keep calling out sick or keep calling out because my dog is throwing up and I lost my keys and I have a flat tire and there was an accident on the freeway and my alarm clock didn't go off? Very different answer if that's the scenario. So we look at the actual pattern. Sometimes when it feels like excessive absences, but we actually spell it out, it turns out there's been 5 absences in 6 months and 2 of them are for legally protected reasons. It feels like excessive absences, but maybe it's not. So that's what we do to figure out, is it truly excessive absences? And you can probably figure out for yourself once you have that kind of spelled out. You can take a look at that and say, yeah, I think any reasonable person on a jury would look at that and say, there's no job protected, there's no legally protected reasons for those absences, and that's excessive. But you can certainly send it to me. I'm happy to give you my opinion. If employee is still within the 90-day probation time, can it be extended? Yes, but keep in mind, there's no such thing, right? So you can say there's a 90-day probation period, but there's no such thing. You can fire them on day 89, you can fire them on day 95. As we talked about at length last month, and there's a link up for last month's program. If you didn't get it, Andrew has a link for that program. As we talked about, I want you communicating with employees, particularly at the beginning of employment, what they're doing well, what they're not doing well, try and getting them corrected. I want you to do a performance review, a sit down, let's go through all of it, at very least at 90 days, preferably at 30 days, 60 days, before 90 days, be communicating. So yes, it can be extended. If you have somebody who they're just taking a little longer to learn, that's fine. But I don't want you to get stuck on this concept of a 90-day probation time. Legally speaking, there is no such thing. If somebody's not working out, I love for them to be terminated before 90 days because somehow in people's minds, it is a thing. And if you are like wanting to do that, wanting to establish this psychological concept, great. Yes, you can absolutely extend it. Do whatever you want to do. If an employee was exposed to COVID, if an employee was exposed to a COVID positive person outside and I make them quarantine, can I have them use sick pay for this? No. So first of all, I'm going to correct your semantics a little bit. You're not requiring them to quarantine. CDC requires them to quarantine. You are prohibiting them from coming to work, right? So those are two different things that legally matters. So you're not allowing them to come to work, and no, you may not require them to use their paid sick leave. They can choose to use their paid sick leave. They can choose to use their paid vacation. And for now, anytime they are isolating or quarantined pursuant to CDC guidance, pursuant to a healthcare provider instruction, pursuant to county health department saying they should quarantine, they are still qualified for FFCRA benefits. Now, you don't have to pay FFCRA benefits anymore. FFCRA expired on December 31st, but the federal stimulus package that was passed at the end of the year says, even though you don't have to, if you choose to, you will still be entitled to 100% reimbursement from the federal government for the FFCRA benefits. So that's through March 31st. It may get extended, but for now it's to March 31st. So my recommendation to employers, if you have employees who need to be out for 2 weeks because they have COVID, they have symptoms and they're being tested, they've had a close contact exposure, and so they're quarantining, I am very strongly recommending that you pay the FFCRA benefits if they haven't already used them. If they've already used them, they're done. It's unpaid time off. If they haven't already used them at any point in the last, 11 months, pay the FFCRA benefits, get your reimbursement from the federal government, have them stay home. But if you're not going to pay them, either because they've already used them or you're just choosing not to, then no, you may not require that they use their paid sick leave. It is their option. When employees have paid sick leave benefits available, it is always their option whether or not to use them. It was one of the many, many dumb ways that I think this law was written. But the way it was written, an employee gets to choose whether to take the time off as unpaid or use their paid sick leave benefits. How often do you recommend we update our employee handbook? Every year. And what I suggest that you do is do a calendar reminder for every December or November or January to send me an email saying, hey, Anita, are there any updates? And then I'll get you the updates. And I'm answering this because this particular person who's asking is my client, and I did her employee handbook. So that's the way you do them. Otherwise, I absolutely recommend that you do them every year. There are rules that change. They usually change as of January 1st. Sometimes they average out, sometimes they change mid-year, but usually January 1. So I think that's a good time to do it. All right, as a point of clarity, should line E in the weighted average hourly rate be different than it is? So let me get to that page. Weighted average, line E, total overtime premium 40.45 times 1.4. No, Kevin, I'm glad you asked that question. So the reason it's not 1. The question is, should it be 1.5 instead of 0.5? So in other words, we're figuring out the overtime, which overtime's at 1.5, right? So should it be 1.5 instead of 0.5? The answer is no, because when you paid that rate, you already paid the straight time. Now you're just paying the overtime premium, which is the 0.5 extra. So in this calculation, you'll see we've already paid the straight time. We've paid the 30 hours. We've paid the 14 hours. So we've already paid the straight time. Now we're just paying for the overtime extra. Sorry, now I'm questioning myself. Weighted average. Kevin, I think you're right. You know what? I'm confusing with the regular rate. All right, everybody, I am going to re-look at that to see if I did that calculation incorrectly. Kevin may very well be right. And if so, when we send you out the certificates, I'm going to send you out that correction. I apologize for that. That may be incorrect. I will get it corrected. Can PTO, vacation, and sick leave be front-loaded after 6-month probation? Yeah, well, yes and no. You can have it accrue from day 1 up through 6 months and then front-loaded at 6 months, but paid sick leave must be front-loaded or accrue from the very first day of employment. There's no waiting period. So you can change it at 6 months. You can front-load PTO vacation at 6 months, but whatever you're using for paid sick leave must be front-loaded or accrue from day one. I think that's it.
Perfect. Yeah, I think that answers all the questions. Just a quick reminder, everyone, I've put a couple of links in the chat. There's a link to Employment Law 101, which can be viewed on demand. Feel free to share that link with your colleagues. Not a problem at all. There's a quick 4-question or something registration form. That's all they have to do to fill out, and then they can watch that at their leisure. The post-event survey, that link is also there, but I'll be emailing that to everyone as well. I read each and every one of these. And I use it to make things better. I take everything to heart. So please take a few minutes and fill out that survey. Other than that, I think this wraps everything up. Anita, thank you so much for joining us once again, coming back year after year to do these with us. I know that all of our clients appreciate them. I certainly appreciate them. I've taken a page of notes. And I'm sure I'll just have questions for you anyways, though. But thank you so much for joining us, and thank you to everyone else, all the attendees that are still here. Thank you for joining us today.
Thanks, everybody. Hope we see you on March 5th for round 3. And if you have questions in the meantime, you have my email address. Don't hesitate to email me. And I am going to say, I think Kevin is correct. So I will send you all the corrected weighted average hourly rate calculation. Thanks, everybody.
All right, perfect. Thank you.